We need somebody to lead the invocation.
John.
Is everything on? I'm so used to looking for Kelly. We have a Kelly. Our administrative assistant, who usually sits in that seat over there where that handsome gentleman is sitting, Mr. Steve McDonald, she had a baby and is going to be on maternity leave for about 2 months, 4 months. But anyway, we'll survive without her, but it won't be the same. I would like, as chairman, to call this regularly scheduled November Tennessee Real Estate Commission to order, and I'd like to at this time call on our executive director to call our roll.
Alexander.
Present.
Collins.
Here.
DeChara.
Here.
Flitcroft. Grease.
Here.
Haynes.
Here.
McMullen.
Here.
Northern.
Here.
Stevenson.
Here. Next on our agenda is our invocation, and I'd like to call on our Commissioner Austin McMullen to lead us in our invocation this morning.
Will you pray with me? Eternal God, we humbly come before you, and we want to express our gratitude for the many ways in which you bless us, for our lives, and for the liberties that we are afforded in this great nation. We want to keep those blessings foremost in our mind and always express our appreciation for the source of those blessings. We pray that you would guide the deliberation of this body, that in all things your will would be done. In your holy name we pray. Amen.
Amen. Thank you, Commissioner McMullen. Next on our agenda is to adopt our agenda. Are there any additions or corrections to our agenda that anybody would like to make?
Mr. Chairman,
Commissioner Grease.
in the event this formal hearing doesn't take up the full day, we have the latitude to, like, maybe move the executive director's report up to this afternoon?
Oh, yes.
Okay, just want to make sure.
Yeah, we have that authority. Any other comments?
Motion to approve the agenda.
Commissioner McMullen makes a motion to approve our agenda, and Commissioner DeShara seconds that motion. All in favor say aye. Aye. Opposed, no. Motion carries. Agenda is adopted. Next, we have our minutes. Are there any additions or corrections to the minutes?
Move they be approved.
Commissioner Grease makes a motion we approve our minutes. Is there a second? Second. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Abstain.
Abstain.
We have 2 abstentions. Let the record show Commissioner McMullen and Commissioner DeShara. They were not here last month. Next on our agenda is a formal hearing. TREC versus Judy L. Jones, license number 270718, and at this time I will turn the proceedings over to Judge Kim Summers, who's going to be presiding over this formal hearing.
Good morning. Thank you, Chairman. Do we want to pass out the notice of hearing and charges? Yes. If the commission members would take a moment to review, and we'll address whether or not anyone needs to recuse themselves from this matter. I have one in my file, thank you. Is everyone ready to proceed? Okay. We are here in Nashville on November 7th, 2012, in matter 12.18-116-426A, and that is in the matter of Judy Jones. And we are here for a hearing before the Tennessee Real Estate Commission. My name is Kim Summers. I am the administrative judge assigned to preside over this matter. All the commission members have had an opportunity to review the notice of hearing and charges. Does anyone have any outside personal knowledge of this matter that needs to be disclosed on the record? Okay, hearing none, we'll move forward. As the administrative judge, I will not participate in making a decision on this matter. My role here today is only to rule on procedural and evidentiary issues. I believe that all the commission members have identified themselves for the record or during roll call. Mr. Chairman, is there a quorum here today?
Yes, Your Honor, there is.
Very good. Would counsel identify themselves for the record, please?
I'm Robin Ryan, from the state of Tennessee.
Okay, and we have Ms. Judy Jones here with us today, and I believe that you are unrepresented, is that correct? And you are voluntarily waiving your right to be represented by counsel today? Okay. Just want to remind the members of the commission that all conversations regarding this matter must be on the record, so no conversations regarding this matter during breaks or outside of the presence of the public should occur, except and the only conversations should occur during deliberations. Have the parties discussed the possibility of any stipulations?
No stipulations.
Okay. And do we have all of our witnesses in the room except for the one that's appearing by phone?
We do.
Do we want to do a group swear-in, or do you want to do them one at a time?
It matters not to me.
Okay, well, do we want to have our witnesses stand up? Okay, the three of them? Okay, and Ms. Jones, do you all solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Great. Okay, are we doing the rule, or?
You'll have to ask Ms. Jones, I have no preference.
Okay, I'm not sure if you're familiar with the rule. That means that witnesses that have not testified do not remain in the room during other witness testimony. That would be your, up
I
to
would
you.
prefer that not.
Okay.
That's the exception to that, Your Honor, is Ms.
Your
Mason.
party, yes. Okay. If witnesses, and who's going to be your first witness?
Ms. Mason.
Okay, very good. If anyone who is going to testify and has not yet testified, wait outside. Thank you very much. And also would advise you not to discuss this matter while you are waiting to testify. Did you have? Okay. The technical record for this matter consists of, if I can find my list. We have a March 30th, 2012 notice of hearing and charges, an April 23rd, 2012 notice of appearance and motion to continue. We have a pre-hearing order issued on April 23rd, 2012, an order denying the continuance on October 10th, 2012, a notice of withdrawal October 11th, 2012, a witness and exhibit list October 22nd, 2012, and a motion to have witness appear by telephone dated October 25th, 2012. And that last motion we did deal with during the pre-hearing conference, and I believe that the state will have one witness appearing by telephone. Is there any other preliminary matters that we need to take up?
Yes, Your Honor. On Monday, I got from Ms. Jones some 90 emails from the weekend, most of them concerning documents that relate to Ms. Goodstein, I believe, but I'm asking without further enough time to address that and to have them sent to Ms. Goodstein for review, that anything that was sent in the email and not on the witness and exhibit list is excluded. And that also includes a letter from the third party that has no authentication, and I would ask that be excluded as well.
Ms. Jones?
I object to that. I received 516 pages from Mrs. Ryan that, as you well know in our discussion on the phone, she was hesitant to send. Still don't know what the postage was on that, and I did not get that until Friday afternoon. So I only had the weekend to review that information.
If this were the first hearing, I certainly believe this would be a particular point. But if the court will recall, this matter was set for last spring when she had an attorney and was continued. Presumably everything, and I know that the attorney and I were in communication when things were sent to her. Whether or not she had communication with her attorney was her problem, not ours. And it is something that had been addressed for the last 5 or 6 months, and therefore again I bring my objection. Especially in light of the fact that nothing can be authenticated because I do not have sufficient time to get any of those documents.
Is this an evidentiary issue that needs to be addressed outside the presence of the commission members?
I don't think so. They don't have copies of it.
Well, and I say that because I'm wondering what's the content of these emails. Were they included in the 500 pages that were produced to the respondent?
No. They are documents that I first saw on Monday.
All right, Ms. Jones, were they documents that you had in your possession?
I forwarded to Mrs. Ryan.
Okay, well, you were required to produce a witness and exhibit list 7 days prior to the hearing.
Not to my knowledge.
It was in the pre-hearing order. So if you did not specify to Ms. Ryan at least 7 days prior to the hearing what documents you were going to be relying on in this hearing, the pre-hearing order specified that you would not be allowed to introduce them into evidence during the hearing.
They were sent to her on Friday and Saturday.
Your
the fact
Okay,
that
well,
she didn't get them.
that's not 7 days prior to the hearing. I mean, there's a pre-hearing order.
Some were sent Sunday, they were sent multiple days. And not everything was sent that same weekend. Most of it was sent the weekend prior to that.
Your Honor, just for clarification, the documents that were sent prior to that were email communication, and they were included in my list of evidence, so I have no objection to email communication. These are documents only that were sent on Sunday to me.
In the order that was issued by Judge Stovall dated April 24th, 2012, at least 7 days prior to the hearing date of this matter, the names and addresses of witnesses and a list of all proposed exhibits shall be furnished to opposing counsel.
The tenant that was in question, Mr. Rawlings, did not submit the letter to me until Sunday, which is the date that I submitted it to her.
Well,
I did not give what I did not have.
I'm sorry, Ms. Jones, but this order was issued in April.
Which is when I consulted with Mr. Rawlings.
So, I mean, you've had
fine.
sufficient opportunity. I mean, we will provide some deference to you in not being represented by an attorney, but when you were put on notice almost 7 months ago about your obligations in appearing in this hearing without an attorney, I can't impose upon the state your failure or your decision not to have an attorney. So, I mean, to a certain extent, you're still going to be required to play by the rules that were implemented, and I think this requirement in the pre-hearing order is pretty clear.
So long as the rules are applied equally across the board, I have no problem with that.
They absolutely will be, Ms. Jones.
Thank you very
So
much.
anything that you did not disclose to Ms. Ryan at least 7 days prior to the hearing will not be introduced into evidence today.
Okay, then anything that Ms. Ryan sent to me on Friday cannot be introduced either. Would that be correct?
No, that would not. Well, if it was included on her witness and exhibit list, and she sent it to you as a result of your request to see it, then it is appropriately introduced into evidence today. If she did not disclose it, then the rule would be the same. It would not be introduced into evidence.
Her exhibit list was vague and ambiguous, as you can see by reviewing it. It was not specific.
Well, and you asked for the documents,
I
and she
did.
provided them to you.
Right, after much discussion with you and her and back and forth, and
But
she
from my
finally didn't send them until
understanding, she's complied with the requirements of the pre-hearing order.
Okay. And what court is responsible for appeals?
Well, I don't think that's an appropriate discussion for us to be having before we even commence with the hearing.
I would like to know if you don't mind.
Your appeal rights will be specified in the order once it's been issued.
Okay. And when will the order be issued?
Would you like me to address that, Your Honor?
The order, I believe there's a requirement for the order to be issued within 90 days of the hearing.
Thank you.
But for the record, if I am tasked with drafting it, it will get drafted the next week, and then it'll just be a matter of getting the signatures. But I'll get it to you if I'm doing it as soon as possible.
Okay, thank you very much, Ms. Ryan. Any other preliminary matters that we need to address before we commence with the hearing?
One short one. In the notice of hearing, there was a Scrivener's error. It's citing to 104 instead of 312, but all the other subsections are exactly the one for 312, and I just wanted to point that out.
Okay.
It's a long error, but it's the same allegations.
Okay. Are we ready to proceed?
I am.
All right. Proceed with opening statement.
Thank you. Good morning. This matter is here this morning based on 2 complaints filed against this respondent, Judy Jones. Each complaint regards how Ms. Jones handled another person's property and money, as well as statements she made that we believe will be shown to be untrue. The proof will show that Ms. Jones was sent each of these complaints, and that despite the law, she has never, including up to today, responded as required by the law. Now, I did not include that allegation in my notice of hearing, but I did want to point it out for you today. The proof will show that her actions are in violation of 62-13-1-2, willful and substantial misrepresentations, failing within a reasonable time to account or remit monies owed to others, violating any rule or provision of this chapter and conduct that is fraudulent, improper, or dishonest. Additionally, proof will show that her conduct is in violation of 62-13-403 in that she did not diligently exercise reasonable skill and care in her actions. Specifically, the proof will show today that Mr. and Mrs. Snider hired the realty store and Ms. Jones as the owner, manager, and broker, and entered into a management agreement wherein she was to manage certain properties of the Sniders. Proof will show that throughout the relationship, Ms. Jones was late in responding to issues, and even later into paying what was owed to the Sniders. The proof will show the Sniders filed a lawsuit and received a judgment in excess of $4,300 for her actions, for which amounts have never been fully paid. This judgment included escrow monies that were supposed to have been placed in an escrow account and other monies owed to the Sniders. Proof will show that sometime in 2009 or 2010, the realty store became, in essence, Great Smoky Investments, LLC, but that no new contracts were provided to any of the witnesses today. Proof will show that Ms. Goodstein also had properties originally managed by the realty store, and that in 2010, then by Great Smoky Managements. The evidence today will show that despite repeated requests for copies of those management agreements, none were ever provided. And at one time, Ms. Jones said, "Oh, it's in storage." Proof will further show that, again, she did not pay or properly account for monies from the property that belonged to other people, specifically our other witness today, Ms. Goodstein. And as of today, Ms. Jones owes Ms. Goodstein a substantial amount of money, including escrow deposits for property owned by Ms. Goodstein paid by tenants. As with the Sniders, Ms. Goodstein will say that she too had a difficult time communicating with Ms. Jones, and that at various times Ms. Goodstein was told her money was either in the mail, already deposited in the bank, or that it was to be interpled to General Sessions Court in Sevier County, which never occurred. Based on this contentious and egregious behavior, we will be asking the Commission this morning to either and/or revoke her license, suspend her license, that she be required to pay a civil penalty, and that she be taxed with all the cost of this hearing today.
Opening statement, Ms. Jones.
It's really sad when someone takes something that someone says is gospel and unfortunately they don't read the documents. The documents have been sent to Mrs. Ryan. She refuses to read them. The documents were sent to Mrs. Ryan. Also, Mrs. Goodstein's property address is inaccurate. It's actually 629 Ridge Road, not 926 Ridge Road. I don't know if that's important or not. Additionally, Mr. and Mrs. Snider's complaint in General Sessions Court was filed in the wrong court, number one, was filed against the realty store and not Great Smoky Investments and not me personally. It was also filed because they do not want to pay me commissions that I am due. It deals with the sale of their property to the tenants, and that I believe will be shown when they answer the questions, assuming they answer them truthfully, which they're not known to do either. And Mrs. Goodstein, by the way, is also not known to be very easy to deal with. She's most difficult to get in touch with. Mr. and Mrs. Snider, you cannot get in touch with them. When they go on vacation, they turn off their phone, and it does not matter what happens to the property. Her son is supposed to take care of it when they're gone. He disappears.
Testifying?
Yeah. No, I'm not testifying. I'm simply refuting what you said. There's a difference. and I'll be more than happy to close at that, and we'll address everything else.
All right, thank you, Ms. Jones.
I will call my first witness.
Thank you.
Eve Maxwell.
Use the mic with that.
Would you please state your full name for the court
Eve M. Maxwell.
and your position with the state of Tennessee?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as that executive director, are you familiar with the license and complaint file of Judy Jones?
Yes, I am.
Can you tell me when she was licensed?
Judy Jones was first licensed in Tennessee on 3/12 of 1999.
And the current status of her license?
The current status of Ms. Jones is licensed. She's an active principal broker with state insurance. Her current expiry date is 3/1 of 2013.
What address do you show for Ms. Jones as her working addresses?
Her working address is 501 West Main Street, Sevierville, Tennessee. She's the principal broker of two firms that are licensed with our commission.
And what are those two firms?
One is firm 261154, and that firm is Great Smoky Investments, Inc. And the other firm is firm number 256280, and that firm is the Realty Store, Inc.
Have you had a chance to review to see if these corporations are active?
With the state or with
the State Secretary of State's office?
I have had an opportunity to do that. Great Smoky Investments Corp. Is listed as of 8/9 of 2012 as dissolution revocation administrative, and so its filing status was changed to inactive administrative dissolved. That was as of 8/9 of 2012. The Realty Store was on 8/9/2012 likewise listed as dissolution revocation administrative, but on 8/23 of 2012 that corporation, the Realty Store, Inc., was reinstated by the Secretary of State. The filing status was changed from inactive, dissolved, administrative to active, and that was as of 8/23 of 2012.
Is this the same Realty Store that was in existence back when she first affiliated with the company?
The Realty Store was first licensed in the state of Tennessee on 3/12 of 1999. At that time, it was a non-resident firm, and it went by the name of Amity Realty, LLC, and it was licensed in Mississippi, and then became a non-resident firm in the state of Tennessee. It changed its name to the Realty Store in 2000 on 5/12, effective 5/12 of 2000, and it was changed to the Realty Store, Inc.
And that's the same corporation or business that you referred to earlier?
Yes, it is.
Okay. Now, do any of your records reflect any past complaints against Ms. Jones alone?
Against Ms. Jones personally?
Yes.
Yes, Ms. Jones has had 7 complaints since she was first licensed in 1999.
Are any of them still active?
There are the 2 that are being heard today, and there's a third one that's likewise active that's not on the docket
The
today.
rest have been dismissed or otherwise disposed of?
That is correct.
Okay, what about the Realty Store?
The Realty Store. Has had 2 complaints filed against it that have been dismissed.
And Great Smoky Investments, have there been any complaints against that company?
So I have to keep shuffling through these files. Great Smoky Investments has not had any prior to the ones at hand.
Now, I understood what you said earlier. Great Smoky Investments corporate status is sort of in a limbo state. Is there any requirement to notify the Real Estate Commission of the changes in corporation status?
No, there is not. We
How about-
required the paperwork at the beginning when you're first licensed.
Okay, how about in names? Is there any requirements to report to the state when names have changed?
Yes, if a firm changes its name, it has to file a TREC 1 and change the name with the Tennessee Real Estate Commission.
And she has done all of that?
She has done that, yes.
Have you had a chance to look at the advertisement she listed as Great Smoky Investments Incorporated?
Yes, I have.
How recently?
Yesterday, last night.
Does it still list as a corporation?
It lists as a GSM is the way it advertises Great Smoky Mountain, engaged in homeowners associations, leasing, sales, rentals.
It doesn't identify itself as a corporation?
It does identify, yes, it does identify itself as a corporation.
Okay. Now, let me ask another question. When a business change, let's say from Great Smoky's Investments to a realty store, what is supposed to happen to any escrows that businesses are holding when they change their name?
The escrow account presumably would close at the former location, the former firm, and there would have to be a new escrow account, security deposit account, opened up in the name of the new firm, and the deposits would need to be transferred to the new firm.
So it can't keep its same escrow account through many names, is that right?
It would have to transfer and name the escrow deposit account would have to reflect that it belongs to the firm that's in control of those security deposits.
Now, today we are looking at 2 complaints. One is 2011-02-0881 and one is 2011-02-1481. Are you familiar with those complaints?
Yes.
Can you tell me when the copies of the complaints and all the exhibits that the complainant sent was sent to Ms. Jones initially?
Well, do you want me, when they were actually sent from our office?
Right.
Is that what you want?
Yes.
August the 2nd, 2011, Ms. Goodstein's complaint was sent.
Wait, before you go further, when you sent that complaint, did you send all the copies of documents that was sent attached to the complaint?
Yes, when we send out a complaint, it does include everything that was attached
To the
when the
complaint.
complaint was filed with us, and any additional information that we might have gotten before it was sent out.
Do you show when it was delivered to Ms. Jones?
It was signed by Ms. Jones on 8/5 of 2011.
Do your records reflect she ever filed a response to that complaint from Ms. Goodstein?
No, our records do not reflect that an answer or response was ever filed.
What is the law concerning when a response is supposed to be filed when you are sent a complaint?
When you receive a complaint, you are supposed to send a sworn and notarized statement in duplicate to the TREC office within 10 days from the date upon which the receipt was signed.
Now, how about the complaint to Mr. and Mrs., that Mr. and Mrs. Snider filed? Can you tell me when that was sent to Ms. Jones?
It was it was sent July the 25th of 2011.
Do your records reflect when it was delivered to Ms. Jones?
It was signed for by Heather Hill on 7/28 of 2011
At what address?
at 501 West Main Street, Sevierville, Tennessee, 37862.
And is that the address you have on record for Ms. Jones?
Yes, it is.
Thank you. Did she file a response to that complaint?
No, she did not.
Now, were all the exhibits and documents sent by the Sniders also included in that complaint?
Yes, they were.
Now, you mentioned earlier there's a law concerning when a respondent has to respond to a complaint. Is that a TREC law?
It's contained within the Tennessee Real Estate Broker Licensing Act of 1973. It's found in Tennessee Code annotated 62-13-313.
Now, what about laws concerning management of other people's money? Is there a law specific about how monies are supposed to be handled?
Yes, there are a number of provisions that relate to that. Some are in the agency provision of the Broker Act, the Tennessee Real Estate Broker Licensing Act of 1973. Some are in the disciplinary section, and then there's some rules that likewise.
In the disciplinary section, what does the law state?
In 62-13-312, there are several provisions. The first portion reads, "The Commission may, upon its own motion, shall, upon the verified complaint in writing of any person setting forth the cause of action under this section, ascertain the facts and if warranted, hold a hearing for reprimand or for the suspension or revocation of a license. The Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a license in performing or attempting to perform any of the acts mentioned herein is found guilty of. One is making any substantial..."
Actually, could you just skip to the one concerning, thank you.
Just this part on the
Monies
monies,
belonging
okay.
to others.
Failing within, number 5, failing within a reasonable time to account for or to remit any monies coming into the licensee's possession which belong to others.
Is there any definition about, in any of the laws, of what exactly a reasonable time is?
There is not a definition of reasonable time.
But what is one supposed to do, in theory, if there is a difficult question about money owed to others?
If there's a difficult question about money belonging to others, there's a rule which states that if there's been a demand for the return of earnest money, that within 21 days that will be interpled into court, and the court will decide the disposition.
Okay, thank you. What about the duty owed to one client? Is there a specific law about what is owed to one's own client?
Yes. In TCA 62-13, 403 and 404, the duty to clients and to all parties, and then the duties to the licensee's own client are set forth. In 6213-403, the licensee must diligently exercise reasonable skill and care in providing services to all parties to the transaction. In 6213-404, any licensee who acts as an agent in a transaction regulated by the Tennessee Real Estate Broker License Act of 1973 owes to such licensee's client in that transaction the following duties. Number 2 specifically is be loyal to the interests of the client. A licensee must place the interests of the client before all others in negotiation of a transaction and in other activities, except where such loyalty duty would violate licensee's duty to a customer under 6213-403 or to another client in a dual agency.
Thank you. Now, when you look back through the history of Ms. Jones, was she ever not the principal broker for Great Smoky Investments Incorporated or a realty store?
She has been the principal broker of Great Smoky Investments since its inception. The realty store she was the principal broker when it was first licensed in the state of Tennessee in 1999, and she continued to be the principal broker until 2004 when Mr. Bob Leedy was the principal broker, and then she became principal broker again. She showed as principal broker again when there was an audit done in 2007. So there was a period of time that she was not the principal broker.
Like only from 2004 to 2007, is that right?
Correct.
I have no other questions for this witness at this time.
Ms. Jones, questions for this witness?
No, ma'am. Thank you.
Do any of the commission members have any questions for this witness?
Yes, I do. Ms. Maxwell, you...
Commissioner Alexander, I just want to remind that so we'll have a permanent record. Does everybody speak into the microphone?
Both of these firms in the same building?
Yes, they are. They both have the same address at 501 West Main Street in Sevierville.
Any additional questions?
I have one. Ms. Maxwell, between 2004 and 2007, when Ms. Jones was not the principal broker at Great Smoky Investments, what was it?
It's
Realty store. I'm sorry, realty store. What was the status of her license?
Actually, let me read these dates exactly. Judy Jones was the principal broker. Just to clarify the record, Judy Jones was the principal broker 2/25 of '99 when the firm first applied and then got its license issued in March of 1999. Bob Leedy became the principal broker on 12/12 of 2003, and he was the principal broker until 2007, and then Judy Jones has been it since then. When she was not the principal broker, she was just a broker at the firm.
Okay.
So she continued to work there. And neither firm shows any affiliates or brokers working there, except for Judy Jones as the principal broker currently.
Judge, Ms. Maxwell, complaint number 1 was received by whom and at what time?
I'm sorry, what?
Complaint number 1, when was that received and who signed for it?
Is complaint number 1 is that the Sniders or?
The Snider was 2.
Okay, I'm sorry, I don't have that information in front of me. Complaint number 1 was received and signed for on 8/5 of 2011, and Judy Jones is the individual whose signature is on the green card that we received back.
But she did not sign for the Snider.
Correct. The Snider was signed for by Heather Hill on 7/28 of 2011. Both went to the same address at 501 West Main Street in Sevierville, Tennessee.
Ms. Maxwell, what's the status of Bob Lee's license? Is he still a broker?
His license was revoked by this commission in 2009.
Okay.
Just for purposes of the record.
It was a hearing, that's why I spoke up, I'm sorry.
Okay.
Yeah, I was there, that's why I spoke up.
Well, we'll have witness testimony from the sworn witness.
Thank you, I'm sorry.
Any further questions? Very good. Thank you very much.
The next witness is Ms. Goodstein, but we'll have to get her by telephone.
Okay.
And I'll rely on Mr. McDonald.
Ms. Goodstein, can you hear me? This is Robin Ryan.
Yes, I can hear you, Robin.
Thank you. Your Honor, she's not been sworn in.
I'm sorry?
I was just telling the judge that you have not yet been sworn in.
Okay. Did I miss something?
Not yet. Just hang tight. Judge needs to swear you in before we can go further.
I'm having a little bit of a difficult time hearing you. You sound far away.
I am. I don't think that'll make a difference. I will speak up louder. Does that help?
Yes, that helps. Thank you.
Thank you.
Judge Summers,
Yes.
do you think we need to swear the witness in?
Oh, absolutely. I apologize. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much.
Thank you. Ms. Goodstein, can you state your full name for the court
Janine, Goodstein.
and your address?
The address here in Miami or
Your address, where you live.
9198 Southwest 128th Lane, Miami, Florida, 33176.
Do you own property in Sevierville, Tennessee?
I do.
And what are the addresses of those properties?
The address is 629 Ridge Road in Sevierville.
Okay, any other addresses?
I don't believe so.
Okay. Who did you originally hire to manage those properties?
I originally, when I first bought the property, was introduced to a gentleman through my bank. And bought the property, hired him, left, and within about a month or so, he passed away.
So then who did you hire?
And then my bank recommended Robert Levy and the real estate store, and I hired them.
And was there ever a time when you did not have Mr. Leedy manage your properties?
Yes.
And when was that?
It was in late 09
Okay.
that Judy Jones called me and told me that Robert was no longer with the company, that he had stolen money and did a bunch of bad things and lost his license, and that she was going to be opening a company on her own, and she would be handling the property by herself, basically.
Did you communicate with then Ms. Jones throughout your time with her, or was there anybody else?
Well, before...
No, once she took over.
I'm sorry?
Once she took over.
Well, I only communicated with her unless I was talking to the girls in the office, which I had to do consistently. I spoke to several girls in her office, or her, if any decisions had to be made.
But can you tell me when the realty store ceased to be the company that originally was involved in handling your property?
Like I said, I believe it was in late 2009 or early 2010.
And what company took over?
Great Smoky Investments, I think.
Were you given a management agreement with Great Smoky Investments?
No, I never got one.
Did you ever get a management agreement with the realty store?
Yeah, I had a management agreement with the realty store, a signed agreement, yeah.
Okay. Did you get regular monthly statements from Ms. Jones concerning your property?
I can't say I got regular monthly statements at all. I constantly had to be on the phone asking for statements. I would not get them on a regular basis. I would be told that they were sent, but they never got there. I would have to call and speak to one of the roles in the office and ask for them to be emailed to me. So I would not say regularly I got monthly statements. When Mr. Levy left the company and Great Smoky took over, and even in the late part of 2009, it was a fight.
Okay. Were you told when your tenants were late in paying?
Not really. In later 2010, well, later, maybe in the first part of 2010, I would get emails saying that a tenant was past due. And in those letters, they would be passed due pretty dramatically most of the time.
What do you mean by pretty dramatically?
Well, I mean, I would get a notice that, for instance, one of the tenants owed $2,000. And then I would see on my statement, if I did get it, that there was an eviction. Well, I would get a notice that there was an eviction, but then I would see on another month's statement that the person was never evicted. So there were like these $400 charges over and over and over. And part of my argument with Ms. Jones is, I thought you were vetting these people. How is it that you're having people come in, taking your money up front, because she would take a chunk of the lease up front, then pay $400 only a few months later to start evictions or to evict them, and then bring somebody else in? It was like a revolving door. I would get a bill, one of the girls in her office, I can't remember whether it was Amber or Heather, would send me these two bills from an attorney dated March 2nd and another one March 8th, same tenant, different amounts of money.
Was that ever? Did you ever get that resolved with Ms. Jones?
No, there was no resolving anything with her.
Okay.
I was on chemotherapy through late 08 and 09, and if I did question her, she was very abusive. She would tell me that it must be the chemo. She would tell me that I was insane. She would tell me that she sent me statements, but I never get them. She would tell me that I could log on to her website or my husband and get our statements and see our banking and see all this stuff and the pictures. And she'd give me codes, but the codes never worked. So, and then trying to discuss anything with her, she would tell me that she sent me emails with attachments of statements and receipts, but there were never any attachments.
Thank you.
And if I did question too much, within, I remember one day within like a 10-minute period, she sent me 20 email after email after email after email, but it was the same email.
Okay, Ms.
20 different times.
Okay, Ms. Goodstein, you filed a complaint with this commission, and with that complaint, do you have a copy of it with you?
Yes, I do.
Okay, with that complaint, you included certain emails. If the court, hold on just a minute. If the court, please, I would like to pass out a copy of the complaint. I'm going to enter it into evidence. And she has a copy of it.
Okay, can I see the...
Sure. This whole thing. Goodstein. Has it, yeah.
And Ms. Jones, you've seen a copy of this? Well, can you pass her, do you have a copy for Ms. Jones?
Yes, I do.
So that she can just peruse it.
you need to just, hold on just a minute, okay? Just a minute.
Yeah, if you would just answer the questions that Ms. Ryan asked for the time being, that would be wonderful. And we're reviewing your complaint at the moment. This is Judge Summers. We're reviewing your complaint, and we'll be back with you in just a moment. Ms. Jones, when you're finished reviewing it, if you would let me know if you have any objection to using this as an... Okay. It may be passed out to the commission members. Thank you.
Now, in your, shall I wait?
That would be great.
Okay.
Judge Summers, if I may inject, I've been watching the clock. If there's any way possible, somewhere around 15 after 10, for us to take a break for about 10 minutes and then continue on until 11:30, at which time we break for lunch. If we could somehow work into those parameters, 15, 20 minutes after 10 for a break and have one break between beginning and lunch break.
I certainly understand that, Mr. Chairman. That's fine. If we can find out from Ms. Ryan how long this witness will take, so we don't have to get her back on the phone.
Well, I don't know how long Ms.
Well, and that I will be asking you, and then also Ms. Jones. I mean, how long do you think we're going to need this witness?
I am about 1/3 through my line of questioning for her.
Okay, and Ms. Jones, you'll have questions for this witness?
Yes.
It looks like, Ms. Goodstein, it looks like there's been a request for a break in 10 minutes.
About 15 minutes. About 15 minutes.
For a 15-minute break.
I'll say in about 15 minutes for a break.
About 15 minutes, okay. Will you be available for us to call you back after that break?
Yes, ma'am.
All right, very good. Fair enough?
Thank you, Your Honor.
If you
Thank
would
you.
continue.
Now, in your emails, it seems that you had several communications with Ms. Jones about not getting checks. Is that right?
Yes.
Can you tell me when you first had a problem, when you first contacted her?
I'm sorry. Would I tell you?
When you first had a problem in not receiving monies owed you and when you contacted her about it? In your emails and documentation provided in your complaint.
Okay, well, I always had problems getting checks from her. In 2009, months and months went by.
Well,
I didn't get it.
okay, well, let's talk about what you provided in your complaint.
Okay. In the complaint, I had not, things had really kind of come to a head. I found out that a lot of the monies for my properties from Amanda Simcoe, I guess, had helped me get, that a lot of monies were being spent on other properties around Tennessee. So I started looking for another manager. And in April, she did the same thing she always does.
Which was?
I sent the check, I mailed you the check, but I never got the check.
Now, Ms. Jones provided to me several copies of emails between you and Ms. Jones, and I see one where you say on June 13th that I never said I didn't get April's report. I never got April's checks or the May report. Did she provide that to you?
She provided me April's report that showed, a page owner, a line that said page owner.
Mm-hmm.
She did eventually provide May's report that showed the same thing, that monies were outstanding and paid to me.
Mm-hmm.
But I never got any money.
Did you ask about it?
I asked about everything, yes, often.
It seems like there's, again, in an email provided by Ms. Jones, she said on June 11th that your checks were mailed to you yesterday to your address. If they come back, we'll give them to your attorney. Did you get those checks?
Never.
And on June 8th, she said, give me your routing and account number and I'll wire it tomorrow. Did you get it in your bank?
No, I refused to give her my bank account number.
And she said in May 31st that her payment, check number in amount of $1785.58 was mailed on May 11th, 2011. Did you get that?
No.
Did you get April's payment?
I did not get April's payment. I did not get May's payment. We found out she collected June's rent. I did not get June's payment. I did not get anything.
So when did you cease using Ms. Jones as the manager of your properties?
Finally, I think officially, and let me explain. One of the things that I found out in getting this transactional report was a payment was made to someone named Ross Gray. A huge payment of about $2,400.
Who is Ross Gray?
So I called Mr. Gray in early June to find out who he was and why he was getting paid this money. And he told me he had sued me and my property. I had no idea. And that Ms. Jones had not returned deposits to my tenant. He sued, he won, and she had to return $2,400 in deposits. Well, when I asked her why that money wasn't paid, first of all, why I didn't know about it, second of all, why that money wasn't paid out of the reserves or the deposits, but paid out of my rent, she got extremely abusive. There were no discussions. I then called Mr. Gray and asked him if he would help me get her out. I believe it was early June. I told her to cease and desist. Please return the deposits, return the reserves, get me my April, May, and June rent, and do not do anything else.
Did you get the April, May, June rents and the deposits?
Nothing.
Have you ever gotten the April, May, June rents or deposits?
No. She put in a statement in an email to me and in a letter to my attorney that she was going to put all the money in General Sessions Court.
Did she?
No. I've been on the phone with General Sessions Court and the two women there monthly. And what I was told and what Mr. Gray was told and had actually continued to tell me was that that's not allowed. That she can't just come in and write a check and put it in General Sessions Court. There has to be a suit. There has to be a case. She can't just give money to General Sessions Court. No, it wasn't there. And quite frankly, from what they were telling me, not to expect it.
Did she ever send you copies of checks where she said she paid to you and that you signed for them?
You mean for this issue?
From May or June on forward of 2011?
Absolutely not.
Okay.
Absolutely not.
Now, in emails also provided by Ms. Jones, I see you requested a copy of the management agreement on April 25th, 26th, and May 2nd. Did you ever get a copy of that management agreement?
Never.
Okay. What did she tell you about the management agreement?
Well, first of all, remember I was on chemo, and so I did have a lot of, my husband told me I never signed an agreement, we never got one. I called Judy and said, Judy, I thought we needed to sign another agreement with your new company. I never got one. Then I was asking her, like you said, to give me a copy of it because she insisted that I had a signed agreement. And she could never produce it. Then she told me that it might have been hidden away in one of the boxes from the old real estate store. But that would have been the old contract with the real estate store, not a contract with her company.
So you never had a written document of any sort for management with her and the new company?
Absolutely, and not that I have anywhere in my files or that I can, swear to you that I ever signed anything, no.
Have you
That's why I was asking her.
Have you reviewed all of your statements and come to a conclusion about how much money is owed you in terms of escrow accounts, that is, monies paid for rent and monies paid for deposits for tenants?
Yes, my accountant, my attorney, my husband and myself have done the best we can. And all we can really go by is what was in that May statement, the April and May statement, that I can prove because, I only get what she allows me to get.
And
so from what I've been allowed to see, there was approximately $1,000 in reserve. There was $5,000 or a little over $5,000. Hold on a minute, I'm trying to find it. So there was like 55, 78, 55 total reserve and deposits held according to her. There were last month's rent. There were 6 tenants in there. All had paid first, last, and security. So there were at least $3,000 in last month's rent. So when Ms. Jones left and the tenants paid their last month's for leases, they didn't pay their last month's rent. They showed us leases from a new management company showing that they had already given the money to Ms. Jones. They also had receipts and different checks showing that they had paid June's money. I was told by several of the tenants that stayed with me that they often paid Ms. Jones cash. So, I can't even imagine what she owes. We also found property after property address after property address where she had paid over $5,000 just from January 1 to October 1 to other properties that when we researched it, they were properties that she managed. Muddy Hollow Road, Happy Hollow, Scenic Mountain Road, Vista Circle. When we researched it, it was Judy Jones' company that all managed these properties, and most of them had out-of-state clients. And in statement after statement, the money was taken out of my rent to pay for lawn, appliances. In several cases, I got a call from one of the girls in her office telling me that she was that Judy Jones was reporting that my property needed repairs, but that she was repairing other properties and getting appliances and taking appliances out of my property. So we found about $5,000 of that money just in those 6, 7, or 8 months. So that's about $5,000. The $5,500 for the deposits that were held, the $3,000 in last month's rent she didn't pay. Then what I can show in the statements for April was about $1,900, I guess. I'm trying to find my April statement, where she showed she paid me. She never did. For May, she showed $1,968. She never paid me. Year to date, in just 5 months, she shows on this statement that she paid to owner over $10,500. It never happened. On one of the transactional reports, I saw my own check where it says paid to owner being redeposited into her bank account, or the bank account that she called, this bank account. So all in all, in just, in less than 9 months, it's close to $20,000.
Have you attempted to hire an attorney to collect your monies?
I tried. What I was told was I needed to wait for the police investigation. The detective Sam Henson is doing a full investigation into what happened, into her not giving any of our tenants their deposits. That I really should wait for that, and quite frankly, I don't have the money.
Are your properties being managed by somebody else now?
Yes,
Are you having any of the same issues?
none.
Are you being paid timely?
I'm sorry?
Are you being paid timely?
I'm being paid every month. I have my statements by the 15th. The checks are to be by the 20th. The property is making money. All units are rented. It is a completely different story.
Thank you. Your Honor, I would like to enter that complaint as exhibit number 1.
Okay, well, we will make the complaints provided by Ms. Goodstein. Is it Steen or Stein? Steen?
Steen or Stein?
I'm sorry?
How do you pronounce your last name?
Goodstein.
Goodstein. This complaint will be made exhibit number 1, and if the court reporter would so mark it. And it appears that now is a good time to take the break requested by the chairman. So, Ms. Goodstein, we will call you back 10 minutes?
Yes.
In 10 minutes for cross-examination by Ms. Jones.
Thank you.
Okay,
Thank
thank you.
you.
Thank you, Judge Summers. We'll take a break for 10 minutes. Judge Summers, I turn the proceedings back to you.
Great, thank you, Mr. Chairman. Do we need to get our witness back on the line?
We do. Are you there, Ms. Goodstein?
Hello?
Are you there?
Ms. Goodstein.
Hello? Hello?
I can hear you.
You can't hear at all.
Is it on
I can't tell what you're saying. Who is this?
This is Robin Ryan again. Let me hang up and we'll try again, okay? Hang up. Hang up.
Yeah, I don't think she can catch them.
This is Denise.
Hi, this is Robin Ryan. Can you hear me now?
I can hear you now.
Thank you. Go ahead, Your Honor.
Am I still sworn in?
Yeah, Ms. Goodstein, please do remember that you have been previously sworn, and you will now be questioned by Ms. Jones.
Okay, Your Honor?
Yes.
Can I make one correction to my statement?
Certainly.
Okay. I was notified just a few minutes ago by my management company now. They were a little late in getting it to me. That out of the 6 units in June, they did collect 4 units, and Ms. Jones collected 2 units. So I wanted to correct that.
All right, thank you very much. Ms. Jones? And Ms. Goodstein, please let us know if you can't hear.
Okay, I will.
I want to ask you, Ms. Jones, to speak loudly and get close and speak loudly into that microphone so everybody can hear, including our witness on the phone.
Okay, I apologize. All right,
Who is that speaking?
Judy Jones.
Well, the man that was speaking is the chairman of the commission.
Oh, okay. I'm sorry. I didn't, okay.
If you need some context, we are meeting before the Tennessee Real Estate Commission, and we have 8 members of the commission with us this morning, and they will be the decision makers in this matter involving Ms. Jones.
Oh, okay. All right, thank you.
And when Ms. Jones is finished with her questions, you may be receiving questions from the commission members.
Okay, perfect. Thank you.
All right, thank you.
Ms. Jones. Thank you. Ms. Goodstein, in your complaint, you stated that you were never paid late fees. Yet in your statement showing May the 1st through May the 31st, you were paid late fees of $290.26 for the year 2011.
I can barely hear you. I'm sorry.
In your statement to the Tennessee Real Estate Commission, your complaint, you stated that I never paid you late fees. Yet, on your statement, you were paid $290.26 through May the 31st of 2011. In the month of May, you were paid $50.43. So you were in fact paid late fees each time they were collected.
Are you asking me a question or are you making a statement?
I'm asking you why you made the statement saying you were not paid late fees when in fact you were paid late fees, and it's showing right on the statement that you sent.
Well, first of all, let me look at the complaint because I don't believe I said I never was paid late fees. That's number 1. And number 2, if I never received any payments at all, then I was never paid any payments at all. So let me review that I do not see on my, unless you would like to point it out to me, that I ever mentioned that I wasn't paid late fees. I wasn't paid at all for April, May, or what we now understand, the 2 units that you collected in June, nor my deposit, nor my reserve, nor my last month's rent. I don't know what you're talking about with late fees.
Matthew Moreland.
I'm sorry?
Matthew Moreland is the tenant's name, and at the bottom of Matthew Moreland's transaction log, You said, "I never received any money for late fees."
I'm sorry?
You said, "I never received any money for late charges." That's handwritten at the bottom of the statement.
This is very difficult to do, so hold on a minute. I never received taking money. Okay, he has Ms. Jones was taking money for late charges and inspections that she was never allowed to take or keep. And again, Ms. Jones, you collected Matthew Moreland's rent in June. I have a transactional statement and his statement showing you did. You never paid me his rent, and you certainly never paid me his late fee.
On your statement ending in May, you were paid late fees for the year of $290.26.
I'm sorry, Ms. Jones, I never got that payment.
It was for the year. It was a cumulative dollar amount. We went through this same episode with 2010.
Ms. Jones, I'm going to instruct you to ask the witness questions.
Okay.
If you want to testify about facts, you can do so during your portion
Okay.
of the hearing.
Great. Thank you very much.
Your Honor,
Yes?
it is difficult for me to know what Ms. Jones has in front of her.
Okay, Ms. Jones, if you're...
Is Ms. Jones telling me she's got proof that she sent that payment, or is she just making a statement that she did?
Okay, if you're going to ask a question of the witness in reference to a document, if you would let the witness know what you're referring to. But if you want to generally testify to that document, then I'll ask you to do that in your case in chief and just ask questions of the witness.
Okay. The questions all deal with the official complaint that was filed by Mrs. Goodstein. All the questions are taken from this document.
Okay, but you might want to let her know what page you're looking at.
Okay.
That would be helpful.
The page I'm looking at is the owner's statement for May the 1st through May the 31st. It has a line drawn, and then it further has, then you go to the April statement, which has another line drawn.
I see what you're looking at, Ms. Jones. You're looking at the May statement where you're showing that you took in rental income of $14,000, late fee income of $290, correct?
Yes.
Okay. I never received May's payment from you, Ms. Jones, and I only received, I believe, 2 checks from you at all, and might have been 3. I'll get the accounting. So, I don't know what you're talking about.
On Matthew Moreland's statement, the transaction log, you state that you never received vacancy payments. For
What? I'm sorry, I can't hear you.
vacancy checks. When we would go out and check the property because the tenant had not paid their rent, we would go out, we would charge the tenant a $45 charge, and then if they were there when we got there, we credited the $45.
Ms. Ryan, if you
Do you
want to make
see
an
that?
objection.
Object to her testifying on it?
Ms. Jones,
No,
again.
I'm not trying to testify. What I'm trying to do is direct her to where she's talking about.
Okay, well, you need to ask questions of the witness.
Okay, the question is,
What page she's talking about?
the Matthew Moreland transaction, which is the one, they don't have page numbers.
Well, how do we know it's a Matthew Moreland one?
At the top, it says transaction log, top left-hand corner. It's right after the urgent 865-774-0006.
Is the transaction log, is that the one that says at the top transaction listing and it's starting December 2007?
Yes, ma'am.
Okay, well, maybe what we could do then is specify of what page we're on that log.
We're on page 1, the first
Okay.
page.
Did you hear that, Ms. Goodstein?
No, I didn't hear that.
The transaction listing that begins December of '07 is generally what we're referring to, and we're on the first page of that document.
Of the transactional listing, can you, what does it say at the head of it?
In bold,
Listing all transactional customer name?
it's at the very top, it says transaction listing in bold, and then underneath it, all transactions.
Yes, and then what else?
Well, that's the first page that we're looking at.
Okay, I don't have that.
Oh, that first page does say Matthew Moreland.
Right, I only have the first page of that, that's all I ever received.
That's all.
And it
Sure.
says on the bottom of page 1, Your Honor, that I have, it is page 1 of 1.
Okay, I was thinking that all of these documents were related. That was my mistake. So it is just one page.
Okay.
I was looking at the owner bank activity and thinking that that was all one document.
No, I only received this one page, which again shows at the bottom of it that this rent was paid on June 3rd.
Ms. Jones, if you would proceed with your questions.
Thank you. Who wrote the complaint for you, Mrs. Goodstein?
I'm sorry, I can't hear you.
Who wrote the complaint for you?
Who wrote it for me?
Yes.
What complaint?
The complaint with the Tennessee Real Estate Commission that you filed.
I wrote it.
Okay, and the additional information that's typed, who wrote that information for you?
I wrote it.
Okay, and who gave you the verbiage for it?
I wrote it when my husband did, both of us. What do you mean the verbiage for it?
The wording.
I wrote the complaint.
So all of the wording is totally from you?
Yes, ma'am.
Okay. Who does your maintenance on your property now?
Objection to relevance, Your Honor.
It will show the relevance.
I'll allow it.
Thank you.
Ms. Goodstein? Did you hear the question?
Did I have a question?
Did you hear the question?
I heard who does the maintenance on your property, and then I object.
Okay, well, the objection was overruled, and so you may answer the question.
Who does the maintenance on my property? I don't know what you mean by that. What kind of maintenance?
Who makes the repairs if there's a repair that needs to be made?
If there's a repair that needs to be made, we get 3 different estimates from 3 different companies, and between myself and Tisha and Bettina, we decide who's going to do the repair. So it's different people.
Who manages your property now?
Bettina and Tisha Morris.
And they're with what company?
They're with Realty Plus.
Why did you not send a letter for the tenant security deposits to be returned to them as requested?
I'm sorry, Judy, I can't hear you.
I sent you a email requesting that you and your husband sign a letter.
I'm going to object unless she refers to the date and the email and where it is so we can see what she's talking about.
Where you sent a letter, an email requesting that you and your husband send a letter releasing the security deposits.
Ms. Jones, I didn't send anything. My attorney did. My attorney wrote you a letter. The letter is I believe, part of this file, asking you to deliver the security deposits, all the rents owed, the reserves, and everything you are holding to his office in Sevierville. Hickman Gray and Associates. That letter is dated June 16th. You responded, no.
When did you fire Mr. Gray? What was the date that you fired him? Or that he terminated the contract with you?
At the end of the month, we didn't really terminate. He still does some work for me, but we decided that an attorney outside of Sevierville would have more success doing you than one inside Sevierville.
Of the tenants that were at the property when I canceled the contract, how many are still remaining at the property?
I don't know, you'll have to ask my rental company.
Are you currently looking for another property management company?
Absolutely not.
What was the name of the person that you said that was in my office that told you I was moving appliances from other properties to your property?
I don't remember. There were several different girls that gave me the.
Ms. Goodstein, you're making quite an allegation. I need to know the name of the person.
Who is asking me this question? Was that you, Jeff?
No, that was me, Judy Jones.
Okay, I'm sorry that I don't remember. You had several girls in that office with like a revolving door. Might have been Amanda, Simcoe, might have been Heather. One of them alerted me.
I'll reserve the rest of it for my testimony.
Okay. Anyone on the commission have a question for this witness?
Also, if I may say so, I don't know if you have it, but Your Honor, do you have something there called Owner Bank Activities dated 1/1/2010 to 10/3/2010?
Ms. Goodstein, I think it would be better if you held that information for a question. Thank you.
Okay.
Ms. Goodstein, this is John Grease. I'm on the Tennessee Real Estate Commission, and I have a couple of questions for you.
Yes, sir. I'm sorry. It's hard to hear me.
Is there any other location for that phone that maybe would be?
Hold on, Ms. Goodstein.
It needs to be directly underneath a speaker, wherever one is up there.
Whoever was just speaking sounds incredible.
It might have something to do with the fact that I am an auctioneer, Ms. Goodstein.
Yeah. You sound great. Maybe they should ask you the questions and you can repeat them.
Okay, thank
Last
you.
thing we need to do is build up bears even.
John, you might need to get closer to the mic.
Yeah, John, lean in
John,
closer
you
to the
might
mic.
need to get closer to the mic.
Just yelling at that thing.
All right, Ms. Goodstein. Ms. Goodstein, can you hear me now?
Well, sort of.
Well, I want to make sure you can hear me, so I'll keep moving up.
Yell at me like you're angry.
I don't want to do that. I have 3 questions at the moment.
Yes, sir.
In months, how long did you have a relationship, business relationship with Miss Jones?
Okay, I want to make sure I understand the question. You asked me how long I've had a business relationship with Miss Jones?
That's correct.
Okay. Miss Jones was part of the company when I hired Bob Levy. I didn't talk to her all that much until more into 2009. So we had a relationship through 2009 and up through when through June, early June when I terminated her.
Early June 2011?
Yes, yes.
Okay. So 2 years?
Yeah, I guess about that, or 3.
Well, so how many checks during that period of time did you receive from Mrs. Jones? Or
I'm sorry, repeat, please.
how often did you get a check from Miss Jones or her company?
You know what, I can't honestly answer that question. There were months in 2009 where I didn't get any checks at all. When I would ask, they were accounting problems, computers blew up. Then one of the girls in her office sent me a statement in November, I guess, showing me that there was over $1,000 in my account. I called Ms. Jones, I confronted her, and in February 2010, she sent me a check for $8,000, saying that was for the month that she didn't pay me in 2009. But no accounting connected to that. And no monthly checks. There were not consistently monthly statements, and with the monthly statements, monthly checks.
Okay, thank you. The second question, I'm confused about who Russell or Russ Gray is. Can you tell me who he is?
I'll tell you, okay. He is the attorney that sued my property in Ms. Jones. When I got a transactional statement back in October 2010, I saw his name with a payment of $2,400. I called him, asked him who he was. He was an attorney in Sevierville. Why did I pay him $2,400? He said, because I sued you, which I thought was rather odd, but I didn't know about that. Evidently, Ms. Jones had rented, this is what I'm being told by Mr. Gray, several apartments to a construction company. When they moved out, she refused to give them back their deposit. He sued for the deposit, he won, and Ms. Jones needed to pay the $2,400 to him. I guess on behalf of his client, that money, as I said, came out of the rent. It was not put in reserve as held security deposit. I then had a contact. I guess what's important for y'all to understand is I live in Miami, well, outside of Miami. I know no one in Tennessee except my bankers, who were the ones that recommended the first management company and then helped me with Mr. Levy. Other than that, I know no one. So when I found Mr. Gray on these statements and called him and had a conversation, I thought, oh God, great, at least I know an attorney there who can kind of help me, through some of this stuff if I need it. That's who he is.
So I'm clear on this. Is it your testimony that you weren't aware of the lawsuit filed by Mr. Gray?
I was absolutely not aware until Amanda, and I'm pretty sure it was Amanda, gave me the correct codes to get into the computer, because there were these codes where we were supposed to be able to go in and get our statements, and for a year I could never get in. Somehow I always got the wrong code. She helped me get in. I printed out this transactional owner bank activity. It's the only one I ever got. It's the only one I was ever able to print. That's it. I've never gotten one before or since, and this is when the trouble began. It's in October when I was able to, and I mean trouble. I don't know if you guys have ever been on chemo or you understand, but you tend to get a little bit of brain fog. So, when month after month I wouldn't get checks and Judy would give me these excuses and Bob Levy stole all this money. And Janine, you're crazy, it must be the chemo. I've told you this before. I've sent it to you 1,000 times. You start to believe that maybe you're a little nuts. I got my husband involved when I received this owner bank activity because I knew I wasn't nuts. There was payment after payment after payment for all these properties that didn't belong to me. There's $2,400 to a Ross Gray. We never knew about it. My husband has to tell me, look, you haven't been doing this alone. We've both been saying something's wrong. So that's when I really started to try to find a way out from Ms. Jones.
Okay, so back to Mr. Gray. So he sued you, or sued Judy Jones's company, you had a conversation with him, and did you subsequently hire him to represent you?
So, yeah, I guess I did. It wasn't until June, though.
Of which,
We had a conversation, he told me, yes, he had sued me, and that was the end of that. When June came, and I decided that I was done with the lies and not getting my checks, I did call him and ask him if he could help me. And I hired him to send that letter to Judy and to please collect the rents and the deposits for me until such time as I could get another manager.
okay, my final question is, there was at least a mention of a police investigation. Can you tell me what you know about that?
What I know is I really couldn't get any help. And, everybody was telling me, I talked to the General Sessions Court. Ross Gray was not somebody I was going to hire to sue Ms. Jones. I really just needed somebody to collect my monies and hold on to it until I could find an attorney that could, that I trusted and knew and that kind of thing. I called the Real Estate Commission. I called I guess it's called the National Real Estate Board. And one of them said, look, you need to call the police. You need to try to get the police to do an investigation if she's stolen all this money from your tenants as well as you. So I did. I called the Sevierville County Police Department. I got a Sam Hinston who said he would help me, that he would at least, write the report, get a case, and start looking into it, but that I needed to understand it was going to take quite a long time, and that in of itself would never help anybody get their money back. So that's kind of been an ongoing thing. But really the thing I guess everybody was telling me is I need to hire a lawyer if I'm ever going to see my money again, and quite frankly I can't afford it. So.
Thank you.
Judge.
Ms. Goodstein, my name is Austin McMullen. I'm a member of the Real Estate Commission.
I'm sorry, what was your name?
Austin McMullen.
Hi, Austin.
I wanted to ask you a couple of questions about some of the documents that are attached to the complaint that you filed. Do you have that document there in front of you?
The complaint?
Yes, ma'am.
Yes, sir, it is.
Okay. I think if you will look, I don't know what order your pages are in, but for me, it's about the 7th page in, and it's the document that says owner's statement on it.
Just a second. I am having a little bit of trouble hearing you, but it says owner statement or owner bank activity.
Owner's statement, May 1, 2011 through May 31, 2011.
Yes, sir, I have it.
Is that a document that was sent to you by Mrs. Jones?
Yes.
And likewise, the next page is another owner's statement that's dated April 1, 2011 through April 30, 2011. Was that also a document that was sent to you by Mrs. Jones?
Yes.
The next page in my packet is a letter that's on Great Smoky Investments letterhead, dated June 16, 2011. Do you have that document there in front of you?
Okay. June 16th, 2011. Yes.
Was that a document that was sent to you by Mrs. Jones?
No, it was not sent to me.
How did you get that document?
It was given to us from Mr. Moreland, I believe.
That letter refers to a $750 escrow deposit.
Yes, it does.
Did you ever receive that deposit of $750?
No, nor the pet non-refundable fee either.
And to your knowledge, that money was never paid into the General Sessions Court either?
No, sir, it was not.
The next page at the top says Schedule of Improper Charges, January through October 2010. You see that document?
Sorry, wait, where are you?
It's
what are you looking at?
a typewritten document. At the top it says Schedule of Improper Charges, January through October.
I can find that one. I'm not in the same order as you. Yes, sir, I have it.
Is that a document that you created?
That's a document that we created. If you go back, do you have a document there that says owner bank activity?
Yes, is that a document that was sent to you by Mrs. Jones?
It was the document that I was able to pull off of the website under my owner bank activity. It says owner bank activity, Janine Goodstein, 629 Ridge Road, from January to October.
Right. And the schedule of improper charges is a document that you created, correct?
Yes, it's a document that I created, but from this document. So if you look at the document that I created,
Right. Are those are
you know, Corey Boulevard, for instance, right?
right? I see it.
If you go back to the owner bank activity, those charges are right here on this owner bank activity.
And you don't own any of those properties,
For instance, if you go to page 2,
right?
under date 3/12/2010,
Right.
if you look at where it says last line, 629 RR all cleaning, carpet cleaning, 2752 Muddy Hollow, dishwasher, $176.
Right.
I don't own Muddy Hollow, 2752 Muddy Hollow.
It
It
is.
has another owner. If you look at the tax records, and Judy Jones was the manager of that property.
And so these addresses that are listed on the schedule of improper charges, none of those belong to you, is that correct?
None of those belong to me.
Okay. I have, we were talking earlier about the page that at the top says transaction listing, all transactions for Matthew Moreland.
Yes, sir.
Is that also a document that was sent to you by Mrs. Jones?
You know what, I can't tell you whether it was sent to me by Ms. Jones or whether I got it from somebody in her office. Honestly, I can't.
Okay, but it did come from her company.
It did come from, I believe this came from, honestly, I can't remember. I might have been able to get into my account again with the help of somebody in her office just for a second. It was in June. I was trying to print out all of them, and I only got one.
So one way or another,
Shut down.
this document came to you from Mrs. Jones' company, either by someone sending it or by you accessing it from their website?
Yeah, it came from Ms. Jones.
Okay. Thank you.
Mr. Northern?
Ms. Goodstein, this is Isaac Northern with the Tennessee Real Estate Commission. Can you hear me?
Yes, I can. How are you, Mikey?
I'm fine, thank you. I've got a few questions also. To be clear, you did receive some payments from Ms. Jones, did you not?
You mean over the years?
Over the years, correct?
Yes, sir, I did, of course.
Were they accompanied by statements?
I can't swear to whether they were accompanied by statements or I would get the check and then I would get an emailed statement. It varied. There was never anything too consistent.
When you did receive statements, did they have attachments as copies of invoices or items that reference the payments that were being made on your behalf?
No, sir. I did get them in '08, through the early part of '09. I think I got 2 of them for the electricity bill in '10. Very easy. Never, I stopped getting all receipts for appliances, lawn care, repairs, paint, anything like that. And when I would ask for them, I would be told I could access them online. And then again, I could never get online.
On the owner bank activity report, it shows on page 4 of 7, owner's distribution redeposited to help pay for bank deposit.
Yes, exactly.
Was that a check that was sent to you for your signature and returned to the company, or did it ever get to you?
It never got to me.
The question, Ms. Jones, with regards to these charges that are questionable for these other addresses that are referenced in your listing?
I did. She didn't, she never responded to me.
And do you know whether or not there was actually an account set up for security deposits?
Do I know if there was? Well, I was told there was. I was told that she would not intermingle monies that were held, any monies that needed to be returned, any monies that were held for my tenants couldn't be intermingled with what she was going in and out of the bank with.
During the time that she managed your property, there were a number of move-outs. Did you ever see, I see one entry for deposit being deposited to the owner's account. Do you know of others that were deposited into your account that were forfeitures for security deposits?
No.
So you were never credited those deposits to offset the expenses?
Not that I ever saw, no. You know, all I started to see was it was just coming out of my rent. You know, what I started to see was you're moving people in, you're taking $300 or $400 for moving them in. Then you're paying some attorney $400 for eviction. Then somehow there's something in there that says, you know, we took $400 on a reservation. It was like a revolving door. Everything was going out. I rarely, let me just give you an example. Since the new management took over and we had to clean up this mess, the checks that I receive every single month in this environment with only one unit, because I cannot rent unit 7, it was so trashed and so damaged, it had to be gutted. This person managed my property. That property was in such disarray. And my checks that I get now are never less than $4,000 or $5,000 a month. And this is in this economy. I never got that kind of money from Ms. Jones, ever.
Okay. I have one last question. In your testimony, you stated that Ms. Jones would charge first and last month's rent plus deposits. Is there somewhere on your report that you can indicate where the reference to the last month's rent being deposited?
No.
How do you know then that she took first and last month?
Well, because when my new, well, first of all, Judy, when I fired her, sent me leases on tenants. So, which, she sent me the leases. So I sent the leases over to the new property manager. She also sent me, as I said, in a matter of 10 minutes, the same April statement 10 times over and over again because she was angry. And the May statement 10 times in a matter of 10 minutes. When we looked at those leases is when we realized, oh my God, she took deposit, she took first and last month's rent, then she took the deposit. Where are they? Where are they? It doesn't add up. It certainly doesn't add up to this. Did you look at May's statement? From 2000, it certainly doesn't add up to a total reserve of $1,000 in security deposits held. $4,500. Where are the last month held? Yeah, and it just doesn't make sense.
Okay. To your knowledge, was a leasing fee a part of your management agreement with the company?
It was with the realty store, yes.
Do you know what that fee equated to? Was it a percentage of the rent or was it a fixed amount?
Well, when I was with it, if you'll give me just a moment, because I can tell you, which is what's another thing. Hold on. New leases, compensation on leases with the realty store was 7%. Renegotiated leases were 7%. Renewal leases were 7%.
Okay. In the document that's titled On a Bank Activity on page 3 of 8.
Yes, sir.
As an example, there is a rental to a Thomas, there's a payment rather from Thomas Ellis, or Tyler Ellis, Thomas Tyler Ellis. And then
Let me
it's toward the middle of the page. The transaction date is 4/30/2010.
All right, hold on, I have to find it. 4:30. What page did you say was on?
Page 3 of 8.
Okay, here. 4:30. 3 of 8, towards the middle. Thomas, Tyler, yeah, what was that?
Okay, if you come down about 4 lines, there's another entry for a leasing fee for that same individual,
Right.
debiting $247.50. Would you say that that's accurate, relevant to the arrangement that you all have? Would you say that that's an accurate amount for the amount of rent?
Yeah, I mean, I would not have drawn flags, but I didn't, wouldn't have drawn flags. It should have been based on my original agreement. If it was a renewal, which is another thing I never knew. Is it a renewal? She didn't send me leases. The first leases I ever got was in June. So is that, I don't have a calculator in front of me. What's the percentage of 1240? It's about 10%, right? A little more?
Yeah, well, there are some other entries for that same individual. I don't know if this is if this is a partial payment or not, but I'm assuming you have an idea of what the rent should be on this individual.
But I don't. The rent should be, or should have been, $495 per month at that time, I believe.
Okay.
Hold on a second. I'm trying to find my stuff. Yeah, I mean, hold on a minute, I'm sorry, I'm trying to find it. Yeah, the rent was at that time $495 per rental. When you saw, or when I see the entry of 1240, the 247.50 is rounding off to 20% of the lease agreement that she takes up front, or she took up front.
All right. I'm going to go back to my original question, and this would be the last one for me at this point. The owner distribution checks that were credited back, you say that you did not receive. Did you authorize someone to sign your names to those checks so they could be redeposited?
Never.
All right, thank you.
You're welcome, sir.
Any additional questions?
Let me ask a follow-up question. Ms. Goodstein, again, this is Austin McMullen. We don't have, you didn't have a written agreement with Ms. Jones. And so could you tell us, how was the arrangement supposed to work that you had with her? What was she supposed to do, and when was she supposed to do it?
Well, you mean with the new company?
Whenever it went from Bob Leedy, who you did have a written agreement with, correct?
Yes, sir.
And then at some point, Ms. Goodstein took over.
Ms. Jones took over.
I'm sorry, that's right, Ms. Jones took over. What was Ms. Jones supposed to do?
She was supposed to manage my property. She was supposed to make sure that the tenants were happy, that any repairs that had to be done under a certain dollar amount. I do this with all of my properties. You know, if you need to spend more than $250, you need to call. We need to discuss it and make a decision, and I'll give you an approval. Keep a reserve You know, unless it's an absolute emergency and you can't reach me. If there's an emergency, then of course you've got to go do what you got to do. She was supposed to rent the apartment, vet the people that were coming in. I even have emails telling her it is not worth it to me for you to rent those apartments, and then when I'm looking at what you're spending to evict them and the damage that they're doing to them, we're better off leaving them vacant. So if you do not or cannot get tenants, like I tell my property manager now, don't rent them. And with Ms. Jones, now my property manager now, I for sure, after dealing with Ms. Jones, I do not pay up front, you know, so that they rent the apartments, or like what she was doing, rent the apartments, get your $400, pay $400 to some attorney like Scott Hall, $400, then evict them, then re-rent the apartment, another $400, and then all of this damage. It didn't make sense.
What was the amount of the reserve that Ms. Jones was instructed to keep?
She was instructed to keep a reserve of $250. She never did that. She always kept $1,000.
Is that total for the entire structure, or was that per unit?
No, she kept that, and like I told you, I only know that based on her statement. You know, she was instructed by me. Now, there was always money in the account. She collected the rent. You know, if there were emergencies, I would send money. I have no problem sending money. You know, I have no problem using a credit card to pay for anything if something needs to be done. She did whatever she wanted. But my understanding in the total reserve, and honestly, I don't even know what that is. Is that total reserve so she had that money to spend whenever she wanted it? I was never given any, ever since Bob left, and I understand that people think he did what he did, but I can tell you, my statements were on time. I never questioned what was going on. I never doubted. I just didn't. Anything that was going on with my property. From the time Ms. Jones took over, all I got were questions.
You said that she was supposed to maintain a reserve of $250. Was that for the entire development, or was that per unit?
No, that was per unit.
What was your agreement with Mrs. Jones concerning how much she was supposed to pay you, and was there any other thing else besides the reserve that she was supposed to hold on to?
And I'm sorry, it wasn't $250 per unit. I'm sorry. It was $250, period.
Okay.
Other than the money, now please know that that was just to be held out if a refrigerator went down or something happened. She took out whatever money she wanted, needed to pay for the electric and units that were not rented, to pay for water, to pay for the dumpster, to pay all the expenses. That was just, okay, keep that in case something like an appliance goes down or something happens. But if you need more money, as I had with Bob Levy, call me, I'll overnight you a check, I'll wire the money if it's something that needs to be greater. That never happened with Ms. Jones.
Did she ever did she ever ask you to send those additional monies because something had come up where she needed more money?
No, she just never sent me money, and then would just tell me all these additional things that came up.
So Mrs. Jones was supposed to take the income from your tenants and pay the expenses,
correct,
such as utilities, and then
utilities, units that needed to be open, repairs, and I don't mean, I'm sorry, maintenance. And as it works with my management company now, we talk on the phone once a month. We talk on the 10th. These are the rents that were collected. This is what looks like we need to do for the month. Is it okay with you if we hold back $1,000 because this is what we want to do? I shoot them an email so they have something in writing that says, yes, hold back $1,000, do what you got to do, and send me the balance.
So after making those payments, she was supposed to keep a reserve of $250, and then was she also supposed to keep the security deposits?
She was in charge of holding the security deposits for the tenants, yes.
And then she was supposed to pay you everything else that she received over those amounts?
Right, you keep the security deposit. I thought, of course, that the last month's rent was also kept in that pile, as it is now. And then on that last month, you gave that to me, right, as income. Correct? So that's the way I believed it should be done. The $250 was a go without saying. If you needed more or repairs came up, other than emergencies, then we would talk about it, we're supposed to talk about it, and if you need to hold back more, that's fine.
Okay, thank you.
Judge, I've got a couple more questions.
Certainly.
Ms. Goodstein, this is Isaac Northern again. I do have a couple more questions. Did you receive at year-end any kind of financial report or 1099 or anything that would show what your annual receipts were for the property?
I did for 09, I never received anything for 2010. Oh, I'm sorry, for 2011.
You mind my asking?
I believe I did for 2010, that wasn't a problem. As a matter of fact, I did get that, but for 2011, for my January, February, March, whatever she took in for April, May, and June, which I never got paid, I never got a 1099, I never got anything from her.
For 2010, do you recall what that amount was approximately? Total receipts for the year?
Oh my God. Hold on a minute. Honey, that was our 1099 in 2010. Hold on, I can find it. As a matter of fact, I just found it. If you'll be patient. You know what? I had it, and I thought I should really take it. And I didn't. Can I look for it and get back to you on that?
Yeah, it's.
I mean, in case you have other questions, I do have it.
Do you have any idea what your vacancy rate would have been for that year? I know that's it's probably a little bit too technical, but do you know what your vacancy loss would have been for that same period?
No.
Okay. All right. That's all I have, Judge.
Anything further for this witness? Any follow-up questions?
No, Your Honor, I
Ms.
have
Jo-
none.
Ms. Jones?
I can find it if you...
That's fine, Ms. Goodstein.
Ms. Goodstein, I believe that we are through with you as a witness, and we appreciate your participation in this hearing today. Thank you very much.
That's it?
That's it.
Okay. If I find stuff, I know I have it, I can pull my my accounting records. I just didn't know you were going to ask me about it.
Unless Mr. Northern would like to have that follow-up information.
I'm good.
I think he's good with the information he's received. Ms. Goodstein, we appreciate the offer. We're done.
Okay, well, thank you all very much.
Thank you.
I really appreciate
Thank you.
Thank you.
giving me the opportunity. I appreciate it.
Thank you.
Bye-bye.
Thank you. Bye.
Well, we are at 11:30. Mr. Chairman, would you like to proceed with another witness or break for lunch or?
Our lunch break is supposed to start in about 3 minutes. I don't think we can get through our next witness in 3 minutes. So let's break for lunch. We have an hour and a half on our agenda for lunch from 11:30 to 1. Be back here at 3 minutes to 1. We are dismissed until after lunch.
Do that, I'll get it presented about 10, like briefs, that's what you told me. Off the street. All right, thanks a lot.
I call this meeting back into session and again turn it over to Judge Summers.
Thank you, Mr. Chairman. Ms. Ryan, I believe that you are on your next witness.
I am, and I call Dwayne Snider.
I believe up there. Yes.
Sorry, you weren't here. Sorry about that.
And if you will remember that you've been sworn. If you will remember you were sworn this morning.
Yes.
Could you please state your full name
Dwayne Emery Snider,
and your address, Mr. Snider?
3406 Cove Meadows Drive, Sevierville, Tennessee.
And do you own rental property in Sevierville as well?
Yes.
What addresses?
2709 John Spears Way and 2713 John Spears Way in Sevierville.
And who manages those properties for you?
Now, me.
Mm-hmm. I'm sorry?
Now I do.
Was there a time that Miss Jones managed the properties?
Yes.
And when was that?
Approximately June of 2007 to about July of 2009.
And what company was the contract with at that point?
Realty store.
Okay. Did that change?
Well, the company changed hands, or changed names. They sent us a letter and said the realty store would become Great Smoky Investments, and that everything else would stay the same. You know, like even when you went on the website, it would direct you right, the realty store website, right to Great Smoky Investments. So, but we never got a new contract.
You never got a new management contract with the new management company?
No.
Who was your contact with the realty store?
Judy Jones.
And what problems did you have, if any, with Miss Jones?
Well, we had late payment on collected rents. Let's see, we had tenant issues that weren't addressed.
And what do you mean by that?
Well, I remember one time, the two properties we own are right next door to each other on the lots on each side, and one tenant on one property had been there for a while, so they had our phone number. Well, the other tenant had said they had been calling the realty store and nobody was ever getting back with them, so they got our phone number from the other tenant, and they contacted us, and then I went out and took care of the issues with the property.
Okay. And were there times you didn't receive rents that were paid or other monies?
Well, I received them, but they were late.
They were late, okay.
Yes.
How did you address this, all of these issues?
Well, I started off with phone calls, emails, stopping by the office to find out what was going on, the realty store office in Sevierville. But I continued to escalate it to certified letters, and then hired an attorney.
Okay. If I could take a moment, Your Honor, I'd like to pull up the complaint and give them a copy of the complaint to look at.
Okay.
And the other commissioners as well. If you would give one to her.
Are you going to be entering this?
I am going to be entering that as an evidence.
So if you would pass a copy to Ms. Jones and myself, and we'll review it, and then we'll pass it on to the commission members. Thank you. And this was the complaint submitted by your witness in its entirety?
In its entirety.
Okay. Ms. Jones, any objection to making this an exhibit?
Just one moment. Compared to what I received. This information was only in Ms. Ryan's documents that she sent. All of this was not in the original information that was sent to me.
Your Honor, Ms. Maxwell testified that all the documents and exhibits to the exhibit were sent to her initially when the complaint was filed.
She may have testified to it, but she did not. Possibly she directed someone to do it, and they didn't send everything. The only thing that I received was the information here in the beginning.
Which information would that be?
The cover sheet here. This letter dated June the 13th, 2011. And the property management agreement only had 2 pages. It did not have 3. And it did not have the Snider signature on it, the one that I got.
Have you seen this complaint in its entirety at any time?
It was in the package that Ms. Ryan sent that I received on Friday. All of this information was.
All of that was included?
It appears that this information was.
Okay, so you have had an opportunity to review.
I reviewed, I did not get, I don't think, all of these emails.
Well, pending the witness's testimony that this was the complaint that was submitted to him in its entirety, then we will go ahead and enter it into evidence as Exhibit 2.
Thank you.
Would you mind?
And can we have the witness so stipulate
Yes.
prior to passing the document out to...
I will have him look at it.
Okay.
Have him look at it.
All of this?
We just want you to verify that this was the complaint that you submitted.
Yes, this is.
Okay. We'll mark
Thank
that
you.
as Exhibit number 2.
Thank you.
If you would just give that, well, she can do that while, okay, documents are passed out. Exhibit number 2. You know what, we'll just switch.
Thank you. Mr. Snider, would you please look at an email from you dated July 21st of 2008?
Is it in here?
It's in there, It's the first email in your documents.
I'm sorry, Ms. Ryan, what was the date on that email?
February 21st of 2008. Sorry about that.
That was the confusion.
It was. Have you found that email?
Yes.
Why did you write that email?
Well, whenever I entered into the property management agreement with the realty store and Ms. Jones, she stated to me that you have to be actively involved in your properties for certain tax reasons. And I said I wanted to be actively involved in my properties. I just was wanting somebody to screen tenants and take care of that aspect. But both of those houses, I built them myself. And some of it I hired out to subcontractors, and a lot of it I had warranty on the property. So I wanted any tenant issues to go through me.
Go ahead.
And I sent this letter because there was some tenant issue, and in this situation, I believe it was that they sent them out, and I wasn't aware of it. And then when I was aware of it, I found out it was the tenant that plugged up a toilet. The kids had put toys in the toilet.
And how did she address that with you?
I guess I don't know really what you mean.
I mean, did she take care of it? Did she tell you what had happened? Did she tell you what monies were or anything?
Oh, well, I didn't get a copy of the bill
Okay.
for it, so I got a copy of the bill, and then, at first, I remember she stated that, well, it's normal to charge the homeowner until the tenant pays the bill, and so, I thought that was kind of odd, but I believe the next month or the following month, she took it off of her statement.
Okay. So she did finally take care of that?
Yes, she did.
Okay. I also see an email from you on or about September 13th, 2008, where you also had some issues?
Is that the next one in line?
Yes, it is.
Okay.
And what were the questions there?
Oh, okay. The one where the pet fee from the prior tenant? Mm-hmm. Okay, the pet fee hadn't been released after the one tenant had moved out and a new tenant was coming in. And the management fee is supposed to be 7% of collected rents, and it was higher. Mm-hmm. And let's see, and the leasing fee was higher than the agreement.
Did she address that?
Yes.
She paid you what she owed at that point?
I know that there's some pet fees that she did not pay, and was this one of them that wasn't paid or not?
Okay.
You know what I mean? It's been what, 4 years now? I'd have to go back and actually look and see which one.
Now, if you look at, there's a message dated from you. It looks like, actually it doesn't have a date, but it says RE May 22nd through June 22nd, 2009 statements.
Is that a different piece of paper?
Yes, and on a different sheet.
Okay, the next one?
It says at the top, May 22nd through June 26, 2009 statements. Up at the top. It's Julie. Do you think we can help them find that?
It says across the top. I thought maybe they were in order.
Okay. No, I don't know what order yours are in.
Okay.
Did you see that document?
Uh-huh.
Yes. In that, you said the payments for the rents were not included in the statement, nor the deposit was made? Is that right?
Yes, that's what I stated.
And was it true that you didn't get the rent deposits?
Okay, well, what this one was for was when the second tenant moved into that same property, 2709. There were some issues with their credit worthiness, I guess I should state. But I was told that if we accepted these tenants, that they had, I believe, an inheritance or something coming through, and they were going to prepay their rent. Okay. Well, after a few months, that never. I just got the normal rent. Well, then I come to find out that they did prepay their rent, and the rent was. I had never collected the rent. It was never paid to me, and then there was some kind of, again, another accounting issue that was out there at their place, and I was never getting any rents whatsoever for that property until I made some phone calls. When I did finally get the rents, they were 195 days late.
Over 195 days late?
Yes, 190 from the time she collected it. I ended up having to go to the tenant and get a copy of the canceled check, and then compare it to the date that I got the check, and I believe it was 195 days.
Okay, and did she at any time say that she would do direct deposits for you?
They were doing direct deposits. Things would start working again good, and 2 or 3 months in a row, the direct deposits would be made on time and everything. And then all of a sudden, it would hiccup again. There'd be another excuse, and then there would be no direct deposits. And then this one was supposed to be direct deposited. She told me she'd have it in on Friday, and it wasn't direct deposited. The following week, I went down again, visited, tried to find out. Finally, I just stood in the office until she wrote me a check.
Okay. And would you look, there's a letter from you to Ms. Jones dated July 31st, 2009 in your documents?
July what?
31st, 2009. It's a letter dated from you. Julie you mind helping me find it? July 31st, 2009.
Does it look like this?
It looks like that.
Okay, that's probably why. Okay, there it is.
Okay.
That's the first certified mail letter.
And what prompted you to send that letter?
Well, I had enough. I was done. I mean, what happened is when I actually went and visited the attorney after I got that check, you know, with all those stall tactics, I just said I had enough. So I went and visited the attorney, and then the attorney, he just charged me for an hour of consultation, and he gave me advice on what to do. And then I worded this letter. He went through the letter with me and had me change it a little bit and gave me advice on what to do to try to just cancel the contract with her, recover the deposits that I had, and so that's why I sent this letter.
Okay, if you fast forward to a letter from you dated October 10th, 2009?
Yes?
And I see in that letter, you said that on July 31st, 2009, you had terminated the contract and gave her 60 days and asked her for the truant account statement, the account and the funds and the owner's account, escrow accounts. Did you ever get that?
No.
And you say in this letter that there was about $4,000 owed to you. Was that right?
Yes?
And did you get that money?
No.
So what did you do next?
Well, I sent the letter on October 10th saying I still hadn't complied. Then I hired the attorney. Then I took her to court and with the attorney, sued her, and we won in court.
Okay. Did you include a copy of that judgment in your complaint?
Yes.
Okay. And what happened? Were you awarded a judgment?
Yes, we were awarded the judgment on all counts, and we awarded our attorney's fees, and the attorney found, the judge found that the contract was canceled because she had violated the contract.
Did the court, if you could look at that judgment for me, it's included in your documents, and look at page 2 of the document, of the judgment. Page 2 at the bottom, it says page 2 of 3 of the judgment. Julie?
There's just a lot of papers.
I know, okay. On page 2 of that document of the judgment, could you look at line, fact-finding number 8?
Okay.
And what does it say?
That defendant first breached the property management agreement.
Okay, did she sue you for a breach of the property management agreement?
No, I don't believe so.
Okay. Did she sue you that she, under slander? Did she?
Yes.
And what did the judge find as far as slander?
No basis.
Okay, could you read number 10?
That defendant did not prove by preponderance of evidence that it was slandered by plaintiff.
And on number 11, did she ask you for commissions of some sort? If you look at number 11, so was commissions a part of her request in the lawsuit?
Yeah, she wanted a cancellation charge or something like that.
And what did the judge determine in number 11?
No.
Well, can you read it for us?
Oh, I'm sorry. That defendant did not prove by a preponderance of evidence that it was entitled to any commission under the terms of the lease or for future commissions for the sale of the properties.
Thank you. And on the next page, if you could, we're going to go through what the judge ordered, and starting with A.
Next page. Okay.
What does A say?
That the plaintiff's request for the return of all security deposits, the pet deposits, and deposits related to the property management agreement, which totaled $4,100, all now held by defendant, is granted.
And B.
That the plaintiff, Dwayne and Nancy Snider's request for reimbursement of $299.10 is granted.
And C.
that the plaintiff's request for reasonable attorney's fees are granted in the amount of $1,300.
And D?
That the defendant's claim for slander is denied.
E?
That the defendant's claim for commissions under the leases and on any future sale of the property is denied.
And the last one?
That all costs of these actions are taxed against the defendant, for which execution may issue if necessary.
And the date of that judgment when it was entered?
23rd day of July of 2010.
Now, after you got the judgment, what did you do?
Well, through the attorney, first of all, the attorney advised me that Mrs. Jones' attorney was going to send the funds, but then nothing ever came.
Okay.
So then he garnished the escrow account at Tennessee State Bank, where it was said it was going to sell.
And how much did you get from that escrow account?
I don't remember the exact dollar amount, but it wasn't enough to even cover my attorney's fees.
So you never got the $4,100 that should have been in that account?
No.
Did you ever get an explanation why those funds were not in that escrow account?
No.
Did you attempt to collect it at any other time from her?
Yes.
And what happened?
It came back as no money in the account.
Okay. And since then, have you also attempted to collect from her since 2010 and subsequently?
Well, by sending the letter to the Real Estate Commission, the Better Business Bureau, the Knoxville Board of Realtors, the Smoky Mountain Board of Realtors. I think there might even been more places that we sent letters to.
Have you ever received all the monies that was awarded to you in the judgment?
No.
Do you have somebody else right now managing your properties?
No, I'm doing it myself.
That's right. Are you having the kind of problems now with your tenants or getting paid that you had when you had Ms. Jones?
Oh, no, I'm having no problem.
Okay. I have nothing further for this witness.
Ms. Jones, questions?
Who's the tenant at 2709? John Spears?
Excuse me, Ms. Jones, if I could encourage you to, once again, speak loudly and closely into that mic.
And I'm going to object to the relevance as to who the tenant is at present with Mr. Snider.
We'll give her a little bit of leeway.
No, it's now for some reason. No, it's in my phone. But it's a new tenant since then. They just came in a few months ago. It's gone brilliant. No, it's Charles, but I can't think of his last name. My wife and I know when she testified, or I can look in the telephone.
It's fine. If you don't remember, just say, I don't remember.
I just don't remember the last name.
Okay, and who's the tenant at 2713?
Joe and Tanya Hartsock.
Okay. And on the Hartsocks,
Oh, I remembered the name. It was Kittredge. I'm sorry. I knew it would come to me, but it was Charles Kittredge on the first property.
on Mr. and Ms. Hartsock,
Yes,
are they purchasing that property right now? Are
No.
they just on a straight lease?
just on the lease.
Do they have an option to buy that house at all?
No.
And what's the rent on that property?
I'm going to object again. It's goes beyond the scope of direct, and it doesn't have anything to do with the facts here today.
Ms. Jones?
It does have relevance, ma'am. This was on commissions. That's, the whole thing is about commissions.
Your Honor, a court already found that there were no commissions awarded or due to Ms. Jones. That's a dead point.
No, ma'am, it's not, because the court was wrong in their findings.
Well, ma'am, you're not at liberty to question the judgment of the court in this forum.
Okay.
You need to limit your questions to issues that are related to this forum.
This is an issue, but that's fine.
Well, I mean, if you want to tell me how it's relevant to the matter that's pending before the commission, then I'll allow it, but I mean, Ms. Ryan has made an objection, and so I'll need to know why it is relevant.
Because the original complaint was filed stating that I had breached the Tennessee Landlord-Tenant Act by not responding to the tenant. I responded to the tenant's repairs and needs for their repair. But in order to get this to court, and if you read through Mr. Johnson's emails, you will find that Mr. Johnson is telling them they've got to get the Heart Sox involved in this in order to make the security deposit an issue, in order to get out of the contract. They owed me commissions on the new lease, which was $300, plus the commission until the Heart Sox moved out, and commissions until the other tenant moved out of 2709.
Let me just ask, are commissions at issue in this forum?
No, no, Your Honor. Commissions are not something this commission has any holding power or law over.
Ms. Jones, if you want to, I mean, I understand what you're suggesting is that this witness endeavored to pull other individuals into his complaint. Is that your contention?
If you read Mr. Johnson's emails, you will find that that's not only my contention, that is Mr. Johnson's.
Okay, well, I think it's perfectly, you're at liberty to argue that in your case in chief.
Okay.
But, I mean, I think right now that these questions are kind of far afield from that testimony.
Okay. May I ask who, Mr. Snider stated that he built the property, that he built both of the homes, and that was the reason he wanted to do the repairs and everything. Does he have a general contractor's license?
No.
Okay. Did you have a general contractor helping you build the homes?
No.
Thank you.
I have nothing.
Any questions from the commission for this witness? Please.
Mr. Snider, did you file this complaint with the Tennessee Real Estate Commission because you couldn't collect after the court case was over, or did you intend to file it all along?
No, I believe we filed it afterwards, but not because we couldn't collect, but because we just want this to happen to somebody else.
So money's a secondary issue?
Well, I mean, obviously you can probably tell by my complaint that I'm not going to just let this rest, and I have other avenues that I'm going to continue to pursue to collect those funds. But I'm giving the Real Estate Commission an opportunity to first before I move further.
Thank you.
Anything further for this witness? Anything further from Ms. Ryan or Ms. Jones? Thank you very much. Thank you very much.
You can leave that. The next witness I'm going to call is Nancy Snider.
Yes, ma'am. And if you would remember that your testimony will be sworn from this morning.
Okay. Would you please state your full name?
Nancy Ann Snider?
And are you related to Dwayne Snider?
Yes, his wife.
Okay. And do you know Miss Jones?
Yes.
And how do you know
Miss Ryan, if I could, for the record, just lean forward and talk loudly in that microphone, please, if you would.
I'm a little short.
And how do you know Miss Jones?
We hired her to manage our properties.
When was that?
Back in '07, June, I believe.
And did you have a contract with her at that point?
Yes.
With what company?
The Realty Store at the time.
Okay. At any time did the company change?
Yes.
What did it change to?
It changed to Great Smoky Investments.
Were you provided the new contract?
No.
Were you notified that the Realty Store would be no longer?
Yes, she said they were one and the same.
Okay. What problems did you and your husband have with her management of your properties?
Bookkeeping errors, untimely payments. Well, the biggest one now is we're waiting for escrow money to be returned. Phone calls not received from tenants. There's quite a few. In my notes, I've got quite a few. It's been just numerous. 1099 not received. One received late. Some statements we never got.
And did you attempt to terminate the contract?
Yes.
And what happened?
We didn't get a response back from Judy. And also, we used an attorney, and we had to go through court, go through legal.
Are you saying when you attempted to terminate, you didn't get a response from her at all?
No, we sent the letter in the end of July.
Of what year?
Of 09.
Uh-huh.
And it was a certified return receipt, so we made sure she got it. And we didn't hear anything, and we sent another letter in October of the same year. Didn't get a response from her. And so then our attorney took care of it from there.
And what happened after that?
We filed, I guess they call it a complaint, basically a lawsuit to get our escrow money back.
Did you get that escrow money back?
Well, no, we got a small portion that the attorney was able to garnish from the Tennessee State Bank account.
And how much is a small portion?
About $1,800.
And that's all that was in that account?
That's what we were told from Tennessee State Bank.
So do you know what happened to the other monies that were supposed to be in escrow?
No idea.
Did she ever tell you that the monies were in escrow?
Yes.
And did she ever tell you what would happen to the monies or where they would go or anything?
She said they were in court, and in the answer to her complaint, she stated they were in a Tennessee State Bank account per the state law, and she said what the law was. I don't have that offhand.
And then your attorney attempted to collect and the monies weren't there?
They weren't there.
Have you attempted since then to collect on the judgment?
Yes, I just did it this year. I believe it was in April.
And what happened?
There was no money there.
Still the same bank account?
Yeah. Yes.
Have you been ever given a new bank account in which to try to attempt to secure those monies?
No.
Okay. So when you first sued or first attempted to collect the judgment, that was with the Tennessee State Bank account that she identified as the escrow account?
Yes.
Okay.
That was where the attorney, I guess that's where he got it from her, the attorney.
And did she say any of that in court as well?
Yes.
Okay. Did she also accuse you all of not paying her commissions?
Yes. Well, I don't know. She made a lot of accusations, so.
And did the court find that she was entitled to anything?
No.
Okay. Did she also sue you for slander?
Yes.
And what happened to that?
It was dismissed.
Okay. And so when did you finally get that $1,800? About when was that?
That was back, we got the judgment in, I believe it was finalized in August of 2010. And the attorney, I believe it was the end of that year, sometime after that. I'd have to look at my notes at the exact date.
Okay. So end of 2010?
Yeah, somewhere around there.
And you have attempted since then but still have not collected?
Right.
And did any time you have conversations with Ms. Jones about any of these particular issues you sued under?
Not once we attempted to cancel the contract.
But you did before that?
Well, not about the escrow money. Maybe there are other issues that there was late. We had monies that were paid from one of our tenants that they had paid a large sum up front, and we had a hard time getting the rest of that. So.
And do you remember how much that was?
I believe what was left was $19.99, I believe.
Yeah.
And
how long after was
$29.99.
$29.99. And how long after it was collected did you finally get paid?
Well, they paid up front, and I'd have to check the dates exactly when they paid.
Do you know how many days?
Up front. Oh, it's like at least 190, something like that. 193, I think.
Did you get an explanation for that from Ms. Jones?
No. What happened? We'd get our statement every month. We had 2 properties, and we would get our statement, and we were paid for the one property, and we said, well, why? Where's the rent from this one? What happened? We didn't get an accounting or anything. And they looked back, and then they would pay us. I guess the renters, I forgot how much they paid each month ahead of time, but they would get the statement, and this for like 2 months. Then they would send us the money from that one. They say, oh, for some reason, I don't know why it wasn't sent. Then we get the money, and all of a sudden there was still 3 months left of it. And that's when we found out from the renters, because at that time we found out they weren't getting calls back either. So they had contacted us, and they said, well, we hope you got paid, when we paid in advance that you got the money, and we didn't, and then that's when we said, hey, is this why there's been this accounting problem? So it was just a big mess.
Thank you. I have no more questions for this witness.
Ms. Jones, questions?
Stated it was 193 days. You were being paid each month. So you're going back to the original date, to the date you were paid, and saying 193 days like you were 193 days late.
On that one
When in
payment, we
fact,
were
you
late.
were not.
No, on that one payment, we were late.
You were not late.
Okay. Do you want me to get I can get the exact dates in my notes. All right.
No further questions, Ms. Jones?
No, there's no need.
Does the commission have any questions for this witness?
Yes, Your Honor. I have one for Mr. Snider. In June of 2007 is when you and your husband first entered into a lease agreement, management of the two properties that you own. What were you doing prior to entering into a contract with Ms. Jones and her company? How were you managing these properties prior to that?
We had just built them.
So they were new construction,
Yes.
and you how did you get in touch with Ms. Jones?
We just contacted her. We saw she had a lot of rental properties in the area, and we just, had talked to her about managing them over the phone, and then we decided to use her.
Okay.
Did you get a monthly statement from Smoky Mountain Investments?
From Great Realty Store. She changed right around the time we were
Okay.
leaving.
Well, did you get a monthly statement regardless from the management company?
Most of the time, we got them. Some are late or, incorrect, but, most of the time we got some statements.
Did you often get copies of bank statements showing the balance in the accounts?
No, we never got anything like that.
Did you ever ask for it?
No, we just our statement. We didn't really think about it.
Okay. But I guess at some point, the court or your attorney or someone found those statements and used them to determine how much money was in the account?
Well, he garnished. I don't know where he got the account number, if he got it from the other attorney, because he took care of that part. The second garnishment, I just took the initial garnishment in, and the clerks filled it out from there.
Thank you.
Anything further from this witness? Ms. Ryan, Ms. Jones? Okay, thank you very much. You're excused. Sure. Additional witnesses?
I told Judy Jones.
Where do you want them? The same place.
Over there?
Yes, ma'am.
Do I need to bring anything?
Your Honor, I would like to call Ms. Jones as an adverse witness.
Understood. And Ms. Jones, if you would remember that you were sworn this morning.
Ms. Jones, you were the principal broker for the Realty Store, were you not?
Yes,
Okay.
for part of the time that the Realty Store was in existence.
And you were the person who worked with both the Sniders and the Goodsteins, weren't you?
I was one of the people that worked with them.
Were you the person who worked with them as the principal broker?
Ms. Jones, if you would use your microphone to make sure that everyone can hear your testimony. Thank you.
I apologize.
Thank you, Your Honor.
You were the principal broker, is that right?
Mrs. Goodstein's contract began with Mr. Leedy.
Were you the principal broker at that time?
I was when it began.
And after Mr. Leedy's license was removed, were you the principal broker?
Yes.
Thank you. Were you the one to close the realty store?
Yes.
And why did you close the realty store?
Because we had additional partners come in and they wanted to change the name.
And why did you reopen the realty store again this year?
I did not.
You did not file documents with the state of Tennessee saying it was reinstated?
No, I believe if you look, you'll find that it was Gail Smith that did that.
I'm asking you if you did.
No, I did not.
Okay. Did you notify anybody that the business that you were dealing with, like anybody at the state, that it's now Great Smoking Investments as opposed to the realty store? Did you ever notify?
We filed an application with the Tennessee Real Estate Commission.
And you told them that you're now the principal broker of this new place and no longer the realty store?
Yes, that's what Ms. Maxwell testified to earlier.
I'm just asking you, Ms. Jones. When you changed the name from the realty store to the Great Smoking Investment Corporations, you didn't change bank accounts, did you? For the escrow account?
Yes, I did.
Well,
and the new escrow accounts were put on the application. The bank was identified on the application.
And where is that escrow account now?
Tennessee State Bank.
And what name is under it?
Great Smoking Investments.
But when you changed the names, you didn't give money back to people like the Sniders, did you?
No, because I intend to sue the Sniders.
And you did not make sure that the money that was supposed to be in the escrow account for their properties was in that escrow account, did you?
It's in Tennessee State Bank.
Not at the address or at the account number you gave previously, is it?
No.
And it's not under the realty store, is it?
No.
So the monies you say you moved somehow to a new escrow account with a new name but didn't notify them?
Did not notify the Sniders?
That's right.
It does not state that they have to have the account number. It only states that they have to have the bank.
If you're saying the money is still there, did you not notify them the money was still there in this new account?
The money is still there.
Did you notify the Sniders?
No, I don't speak to the Sniders.
Did you notify your attorney who was representing you at the time that the money was there?
I fired my attorney because he signed the agreement and I personally instructed him not to sign it and to file an appeal, which he did not do.
I don't see an agreement. Do you have an agreement to show me?
He signed the judgment.
That is what the judge ordered, is it not?
And the attorney signed that, and he was supposed to file an appeal, which he did not file in a timely manner.
And the Sniders did attempt to collect the money from the account information they had that you gave, didn't they?
Yes.
And they only collected...
I assume.
And they only got $1,800.
They got
so why haven't you given them back the rest of the money that the judge said you owed them?
They got back the tenant's security deposit. If you go back through Mr. Johnson's information, you'll find that they did.
The judgment says that the tenant's deposits were $4,100. They did not get that from you, did they?
Their security deposit, just because a judgment says something doesn't make it correct. It's like saying, if you look back through the information, you'll find that it's all outlined.
The judgment said that they were owed $4,100 in escrow and other accounts monies, and that money was not paid to the Sniders, was it?
No. The Sniders owe me in excess of $25,000.
The judge said that the Sniders owed you nothing, didn't the judge?
The judge and Mr. Johnson he was a partner in that firm. They're good buddies, and this is the way it works in Sevier County.
The court also said you breached the contract with the Sniders, didn't the court?
Which is not uncommon in Sevier County when you're dealing with Judge Stokes and anyone from the Johnson firm.
And the court also said you had problems due to accounting errors, and you provided to the court. There were problems, didn't the judge?
Read Mr. Johnson's
I'm asking you what the judgment said, Ms. Jones.
The judgment was inaccurate.
But you claimed
that by Mr. Johnson. What can you expect?
You claimed you were owed commissions, but the court said you weren't owed anything. Didn't the judge say that? in the court. After you put on testimony, and after the testimony of the Sniders, and the court heard both of you, the court determined that you breached the contract.
That court was very much like you, and the attitude that you're projecting here, which is really distasteful. You would like to call me hostile, when in fact the hostility is coming from your side of the fence?
I don't believe I called you hostile, Ms. Jones. I'm just
yes,
asking
ma'am,
you
said
questions.
You wanted to consider me a hostile witness. That was what you said, was it not?
She said adverse.
I said adverse
witness.
witness. That's not hostile,
Okay.
ma'am. But this is not the first time you had problems with escrow accounts, is it? Is this the first time?
That I've had problems with escrow? I personally have not had any problems with escrow accounts other than with Mr. Leedy.
Yes, and
Is
the
that
court-
what you're in reference to?
And in reference to that,
Okay.
didn't the Court of Appeals say that you and Mr. Leedy routinely commingled money in escrow accounts then?
And again, Mr. Scott Hall, which is the reason that he was fired, did not appeal the way the court wrote it. It was written incorrectly, and if you go back to the original judgment, in your smirkish smile, you will find that it was written incorrectly. If you go back to the original judgment.
Isn't it true what the judgment from the Court of Appeals said, that you admitted in court freely that you had commingled funds along with Mr. Leedy?
It stated that, but I did not admit that because I've never done that. And
Well,
if you
why
go
would the
back
court-
if you go back through all of my documentation, you will find that I am very protective.
But it said that
It
was
does not matter what it said. It does not make it accurate.
Now, you also had accounting issues with Ms. Goodstein, didn't you?
Ms. Goodstein is an interesting...
Did you have accounting issues with her?
In Mrs. Goodstein's mind, yes.
Did you?
However, if you will look through those emails, you will find that she sent me an apology email that said, "I'm so sorry. My CPA looked at everything, and everything for 2010 is perfectly fine. We don't have any problems."
But you had problems in 2011, didn't you?
And again, Mrs. Goodstein was sent information. The reason we changed from rent manager to property wear was because in rent manager, when you have a repair issue, all the checks... Are you interested, or are you just going to ignore me?
Your Honor, please.
Ms. Jones, please answer the question. Ms. Jones, you're testifying for the benefit of the commission regardless of Ms. Ryan's level of attention.
Thank you. In rent manager, when you type up checks for maintenance and repairs, whatever the first property on that check is, it would throw the name of that property on the bill, which caused massive confusion. We attached copies of the repair bills to try and clarify the problem, which Mrs. Goodstein received. Also, Mrs. Goodstein was very mistaken in all of her dates. Mr. Leedy's contract with my office was canceled in September of 2005. He actually left my office in January of 2006.
Did you provide a new contract to either the Sniders or the Goodsteins after the realty store was no longer?
The contract was with the realty store.
Yes.
The Sniders were never a customer of Great Smoky Investments.
Did you provide a new contract for Ms. Goodstein when you
Ms.
changed?
Goodstein was sent a new contract. However, at that time, she was very ill, and she didn't get paperwork back to me.
Did you ever provide a copy of it to this commission or an answer in anything when that was an issue?
I never got a signature back from Mrs. Goodstein.
Now, you sent some emails to her claiming that checks that she was owed were in the mail. Is that right? Did you say that in, let's see, an email dated May 31st of 2011, when you said to her, the checks are, let me find it.
If I said that the check was in the mail, it was in the mail.
And she wrote back and said she didn't get that check.
That does not surprise me with Ms. Goodstein. That was the way it worked with her. She would get confused, and it was really sad. At that time, she was on her second round of chemo.
In 2011?
No.
That's what I'm
We're not
talking about.
In 2010 and 2011.
If I may, for the benefit of the court reporter, we need to try to talk only one person at a time because she can't.
I apologize.
She can't capture two conversations at once.
I was asking you about 2011, not 2010.
In 2011, Mrs. Goodstein was at that point going through foreclosure, and that was her reason for contacting Mr. Ross Gray.
Ms. Jones, there was no testimony about any foreclosure on the record, so...
Of course there isn't, but it is a fact. Mrs. Goodstein was going through a foreclosure.
Your Honor.
Would you re-ask the question,
Yes,
please?
I will. Was there a time when you told her checks were in the mail and she told you she didn't get them? That would have been on or about May of 2011.
If I told her checks were in the mail, they were in the mail.
And then on May 31st of 2011, they have an email that says, well, you know, they're not going to be in the mail, but I'm going to deposit them in a bank account. The same checks.
No, I would have voided the original check and reissued additional checks.
On June 8th of that same year, you told her in an email that you sent the monies on June 10th. Is that right?
That would not make sense. You said on June the 8th, I said that I sent them on June the 10th?
Yes, that's what you said.
That's impossible. You can't say that could not happen.
Okay, so you're saying you didn't say that? Is that right?
There's no way you could send it 2 days out.
And isn't it true that on June 11th, on June 13th, she told you again that she never got April's checks or May's report? Isn't that right? That's from an email you provided to me.
And then she submitted another email to me that said, I never said I didn't get April, I did get April.
No, what she said was she never said she didn't get the April's report. What she said, let me read it to you, ma'am. This is to you from a document you provided to me.
Thank you.
I never said I didn't get April's report. I never got April's check or the May report. Please comply with my attorney's request. Sending this to me and fighting with me every time I ask for something, which is the case, was to deal with my attorney. Just causes me more hardship and isn't doing what I require or requested. Did she send you that email?
Yes.
And she said she never got it, didn't she?
And then the subsequent email that you refused to have admitted, she said that she did get it.
Show me the email you're talking about. Subsequent to June the 13th. Subsequent to June the 13th, 2011, show me the email where you said that she said she got that check.
It's in the stuff you have.
You have all those documents with you?
No, actually, I didn't print them all out because it was a
so you don't have
considerable amount of documentation.
Is that right? So you don't have that, is that right?
I don't have it with me, but you have it in your stack.
And I'm telling you, I don't. I have no subsequent email subsequent to June of 2011 wherein she said she got the money. I have no email to that effect.
Ms. Ryan, there's no need to argue with you.
You also sent her an email on Friday, June the 17th, where you said that if you wish to fight this in court, let me know so I can interplead the money. Did you interplead the money?
She never would send me the documentation. If you look back down through that email, and in one email she sent me, she said, send the tenants back all of the money and cancel all of the services. And I told her to please identify exactly what she means by send the tenants back all of the money.
Let me ask my question again.
Okay.
Did you interplead that money?
I have not. It is in the Tennessee State Bank account.
And isn't it true you sent a letter to her attorney dated June 16th, 2011, where you said all escrow accounts will be placed with the Sevier County General Sessions Court? Did you do that?
No, because they wouldn't accept it. From what I understand, there were other issues.
Doesn't the law require you to interplead money when there's an issue about monies owed to parties that you are representing in real estate?
Yes.
And you didn't do it?
It is in the Tennessee State Bank account.
But you didn't interplead it,
I did not interplead it.
Thank you.
Because Mrs. Goodstein would never respond to my letters. I sent her information and documentation on each one of the tenants. I sent the same documentation to the tenants so that everyone knew. But additionally, Mrs. Goodstein had online access to every account.
My question remains the same. Ms. Jones, you had a requirement and responsibility to attend to this by the very minimum of interpleading the monies in court since there was dispute. And in fact, you told her attorney, and you told her, again, I'm going to read you an email from you, June 17th, where it says that you were going to let me find it exactly, all security deposit, pet fees, and last month's rent held in escrow will be deposited with the Sevier County General Sessions Court. But you did not do that.
No.
Have you ever paid her what she is owed, that she says she is owed?
It's still sitting in the Tennessee State Bank account.
And so what is the reason you have not paid what Ms. Goodstein says she is owed?
Because we were pending a litigation from Chris Rawlings and his girlfriend. She fell on the back porch and cracked her tailbone.
Is there litigation
to sue.
Is there litigation pending?
It is now 1 year past the time of the fall.
So are you planning to return the monies owed to her from escrow monies, which really have no relevance to the lawsuit? Are you planning to return those monies to her at this point?
Absolutely. It's her money.
And so why didn't you return money to her prior? And why didn't you return the Snider's money?
The Sniders and I are going to be seeing each other in court.
And that's the reason you haven't returned the money after the judgment came down saying you owed it?
Absolutely.
And that's the reason you changed the money from one escrow account to another so they couldn't get it?
Not really, no.
But you did do that, didn't you?
I did.
It seems to me, from what you were telling me this morning, that none of this is your fault or responsibility? Is that right? Any of this? Any
I'm
of the
not sure
problems?
what you're talking about.
Any of the problems you have with the Snider and the money you owe them? Any of the problems you have with the Goodsteins and the money you owe them? It's not your problem, not your responsibility?
The problem with Mrs. Goodstein is very simple. She has moved... Mrs. Goodstein is now doing business with Realty Plus, who is with Bob Leedy, and who is with Tisha Morris and Bettina Koopman. And Mr. Leedy's trial is coming up on December the 11th,
Honor,
which is the very reason that you insisted this had to be done today.
Ms. Jones, if you would answer her question, and then you can fill in whatever other details you would like during your testimony.
Thank you.
Can you answer my question?
No, it's not my fault.
None of it?
No.
Not with the Sniders where you got the they got the judgment? Not with Ms. Goodstein?
No.
You've done nothing wrong?
No, I have not.
Even though
And
you
all that
changed
money-
money from one escrow account to another so they couldn't get it, you've
It's
done
all
nothing wrong?
right there in Tennessee State Bank,
And you haven't given it to them, have you?
and I don't intend to.
Thank you. I have nothing further.
Ms. Ryan, do you have additional witnesses?
I do not.
Okay. Well, Ms. Jones, since Ms. Ryan has completed her case in chief, I understand that to be correct, Ms. Ryan?
That's correct.
You may proceed with yours.
Thank you.
Judge, do we not get an opportunity to ask questions of the witness?
Well, do you want to ask them now or after she provides her own testimony?
I'll wait until after she provides her own testimony.
Okay.
I don't know how long her testimony is going to be, but I've just been requested by one of our commissioners that we take a short 10-minute break.
Okay.
if we could at this point, it'd be a good time. We'll take a 10-minute break, and I do mean 10 minutes. I want to thank everybody for a speedy return, and at this time, I'll turn the proceedings back over to Judge Summers.
Thank you, Mr. Chairman. Ms. Jones, you may proceed with your testimony and just some limiting instruction. You're at liberty to testify about anything that is addressed in the complaint at issue before the commission today.
Okay. In the complaint, Mrs. Goodstein, I'm sorry, not long enough to reach the thing. Okay. In the complaint, Mrs. Goodstein stated that I did not pay her late fees. She was, in fact, paid late fees, as is evidenced on the statements. She also stated that I charged for vacancies. We did charge for vacancy checks. It was in her complaint. It was at the bottom of the page. That was the copy of the she has a question mark by it, and she stated it in her complaint. So hang on a minute, and I'll show you where she put it. Some difficult reading. Yes, sir, it's on the prevention listing. Says she never received any money for the late fees.
It's on the bottom of this transaction list.
Yes, ma'am.
And that's, it says right there, I never received any money for late something, charges. Is that what you're referring to?
Yes, ma'am.
I renew my objection to anything concerning vacancies. This documents that we have talk about late charges.
Well, I mean, Ms. Jones, you're at liberty to testify about your recollection on the late fees, but it would not be proper for you to testify about Ms. Goodstein's representation of the late fees unless it's contained somewhere in the complaint.
Okay. All right. In her testimony, this thing.
Well, if you would refer to that as the complaint, because her testimony would be characterized as what she provided today.
Okay, her complaint. She stated that I moved someone from her property over to another property that I managed. The gentleman's name was Chris Rawlings.
Can you show us where it says that, please? What are you
Yes.
referring to?
here's the part of the complaint that is to Connell House. Okay, in her complaint that she filed to Connell House on September the 15th, 2011, third paragraph, she states that I moved a tenant out of her property that owed her $3,800. She's overstated the dollar amount he owed. But the reason that he moved...
Does it say? Can you show me where it says she moved? Did she say that? Because I'm missing that. Oh, I'm sorry. Yes, moved from out of my car. My apologies. I found it.
Okay. His name was Chris Rawlings. Mr. Rawlings moved because his girlfriend fell because
It's all hearsay. I have no information or no way to cross-examine about what she says has happened. It involves a third party. I have nothing.
Is this information to which you have personal knowledge?
Yes, I do.
Okay, you can testify to your personal knowledge.
Thank you. Mr. Rawlings moved because his girlfriend fell on the back porch because of the slime and the buildup from the trees that were all hanging over the back porch. She fell and broke her tailbone, and there were some considerable hospital bills and so forth. Then the daughter fell on the front porch because the railing was not repaired and broke her arm. They wanted me to solve the problem. They wanted out of that place as fast as they could, because in their statement, or their statement to me was, it's going downhill fast. And if you look back through Mrs. Goodstein's statements to me, you will find that she ordered us, not only through her letter with her attorney, but through emails, not to make any repairs whatsoever, to stop all services and don't make any repairs, which is the reason that I canceled my contract with Mrs. Goodstein, was because I felt like it was a liability situation that I did not want to be involved in. Mr. Rawlings and his girlfriend moved into another apartment, and it has now been a year since the accident, and hopefully they will not sue. They did have a year from the date, from what the attorney told me, to sue. So I've been sitting, waiting, praying that they didn't sue, which at this point they have not. The reason I changed to rent manager was to make everything visible for the owners. The owners could go online that were internet able, and they could look at their tenant statements. They could look at their owner statements. They could run profit and loss statement, balance sheet, any kind of a statement that they wanted to run, they could run on their property. They could also see every repair that was ordered on their property, along with the tenant's name and the tenant's phone number. That was the entire reason for changing to that program. After we got with the program, we saw a few errors, or not errors, but issues, I should say. And then in 2012, I changed over to PropertyWare, which is a better program than that one, in my opinion. But Rent Manager is still not a bad program. It does provide all of the information. But if I were going to do anything with anyone's money or tell them that a tenant wasn't paying or something of that nature, I certainly would not order a program that gives them clear access to every deposit, and it was in real time. When the tenant came in the front and they made their payment, that payment put into the computer, that owner, which I do have many owners that watch the computer every night, they check it and see if their tenant's paid. Once your tenant's paid, they're fine. If the tenant doesn't pay by the 6th, they're on the phone to me wanting to know what's going on, and of course, I've already been on the phone with the tenant. But if I were going to do something that was not right, I certainly would not order a program that allowed them access to that information at any time. They could run statements for any period. They could run 1099s. They could run a year statement, a month statement, or any other kind of statement that they wanted, in detailed orientation or in monthly orientation, whichever they preferred. It was all right there for them to run, which is how she ran the bank statement. What she did not run was the rest of the statements. For whatever reason, I don't know, but she did have access to those. We emailed those statements, and for tenants that are owners, I should say, that are not internet savvy or that like to have a paper copy along with an email, which I do have 3 that want it both ways, they get an email and then they get a paper copy. And the check goes with the paper copy if they get paper checks. If they get direct deposit, they get a routing number and information telling them where the money was deposited, the transaction number on the deposit, so that they can cross-check exactly when the deposit comes into their bank. I have over 90 owners. I have no problems with any of them. Mrs. Goodstein, unfortunately, was going through a bad time. She had cancer twice between 2005 and 2011. She was difficult to deal with at best, but she was also having a hard time paying the bank. So you never knew if, I mean, she said she would pay you up front about the repairs. No, you had to withhold the money from the payment to her in order to cover the repairs. The $1,700 check, I believe it is, she was talking about, or there's one check she's talking about. She was given an email, the tenant in number 5, 98-degree weather, there's no air conditioning, 2 babies in that house. The tenant's screaming, I'm going to sue if you don't get this air conditioner fixed now. Mrs. Goodstein and her attorney were negotiating with the bank, and she was uncertain as to whether or not she was going to be able to keep the property.
I'm going to object to anything about something that Ms. Goodstein did that was not on the proof or not presented in Ms. Goodstein's testimony. She would have no idea what communications her attorney and she might have had with her bank, or if even there was an issue with the bank.
Actually, Mrs. Goodstein shared all the information with me about the negotiations with the bank and the foreclosures and moving appliances from one unit to another in order to try and keep units happy.
Ms. Jones, you're going to need to limit your testimony to facts of which you have personal knowledge.
I do have personal knowledge.
If it's something that Ms. Goodstein told you about, then you have secondhand knowledge, not firsthand knowledge. So it needs to be something that you know without someone having told it to you.
Okay.
So, I mean, if that distinction is not clear, if you go to the bank and you see how much money is in the bank on your own, then that's something that you know. But if you go into the bank and the teller says, this is how much money you have in the bank, then that's secondhand knowledge. Does that distinction make sense? Okay.
Totally.
So, proceed.
I received a call from Mrs. Goodstein saying the bank was going to come down and do...
I'm objecting again, Your Honor. If that were true, she had plenty of opportunity to ask those questions, Ms. Goodstein, while she's on the stand. And now she's testifying to things that are not before this commission and have not been testified to through Ms. Goodstein.
What is your purpose for providing that testimony?
Mrs. Goodstein was stating about repairs and so forth, and Mr. Ross Gray, and which it's immaterial at
Okay.
this point.
Well, I mean, if,
I have nothing more to say.
questions?
I do, Your Honor.
And do you want to proceed with your questions, or would now be an appropriate time for the commission to ask questions?
I just have a couple, and that might then
Okay.
after that. Now, Ms. Goodstein, you still, Ms. Jones, you still refuse to return Ms. Goodstein's money, but she had 6 units, didn't she? She had 6 units with
She had
you?
a total of 10 units.
Okay, and
But most of them were vacant due to repair issues.
And the 1 unit where you say that people fell, okay, you say you held all the escrows for all the other units based on something that happened?
You know how much attorney's fees are.
And what gave you the right to do that?
Mrs. Goodstein is responsible for the attorney's fees.
She may well be.
Mrs. Goodstein would not pay the bill.
Is it not true that you have no right under any law to hold escrow monies belonging to Mrs. Goodstein on a potential lawsuit against Mrs. Goodstein?
No, ma'am, it is not, because if you read my contract, it clearly states
What
the
contract?
owner, the contract that Mrs. Goodstein had.
Where is that
Uh,
contract?
At this point, none of us have it.
Isn't it true you told Ms. Goodstein you thought that contract was in a box with a realty store somewhere?
No, that's,
You didn't say that in an email to her?
don't believe so, but I'm sure that if you said that I said it, that you can find it, so.
I did. It's in an
Okay,
email
good.
you sent to me.
Okay.
Okay. Now, my next question is, you held monies in escrow of deposits belonging to tenants of Ms. Goodstein. You held that, and you still have those monies, right?
They're still in the Tennessee State Bank.
And you have not, despite numerous requests, released those to Ms. Goodstein.
There have not been numerous requests. All communication stopped.
You also said in an email to her of June the 19th of 2011 that why you held checks in the past, very simply put, I will not pay any of your bills. Is that what you told her?
That's exactly what I told her.
And you told her your lack of address in the HVAC unit cost us both of a lawsuit. What lawsuit?
The tenant that was in there was threatening to sue because we didn't fix the HVAC unit. When I finally got Mrs. Goodstein on the phone after multiple phone calls for several days, she said, I'm not dealing with this right now, I'm on vacation.
And also in that email, you said, I must have an explanation to your statement, return all security deposits and all deposits on pets, electric utilities, etc. Did you do that?
I never got an explanation from her, and I asked, if you will read further, you should find where I asked her to send it signed by she and her husband because they played the back and forth game.
Here's what you said in this email, Ms.
Okay.
Jones. You said, is this property going to foreclosure? Have some compassion for the tenants. Do they need to begin looking for another place to live? Question, do I return that deposit to the tenants? Exactly. Who are you ordering me to return the escrow money to? I will have my attorney file suit in quotes. I hope you are prepared for a real waste of your time and money, not to mention the emotional drain. Threatening me is not the way to get me to do anything. Answering the questions is the only way to resolve these matters. Answer my question. Is this property going into foreclosure? If so, as soon as all the bills are in and paid, forward any balance due to you. If you plan to sue me, then I will deposit funds with the courts until this mess is resolved. Now, did you ever do that? Did you ever return the funds to her?
No, the mess still isn't resolved.
Did you ever interplead with court?
No.
Okay. And isn't it true, when she said, return it to me, she told you, return it to me? You didn't need another explanation, did you?
She didn't say return it to me. I believe it says return it to the tenants, which I wanted her to clarify whether or not she wanted it returned, all of that money returned to the tenants, and if so, to sign it.
She said, return all security deposits and all deposits on pet, electrics, and utilities, etc.
To whom? Does she say to whom?
This is what you're saying.
Okay.
She did ask for that money, didn't she, on more than one occasion?
Look back through there and see exactly what she said. She gave one-word answers.
Okay. I will see an email from you. Here's the email where she states she's holding the money until expenses come in. Again, as soon as I receive all the bills, I will close the account. Until that time, this is your email, June 20th, 2011. Please leave me alone. Also, please instruct your attorney to leave me alone. With any luck, all the bills should be in soon, and I can close your account and be done with you. Tenants escrow accounts, you ordered me to give the money back to the tenants. Are you changing that order? Did you give it back to the tenants?
I didn't get an answer back, did I?
I'm asking you, did you give it back to the tenants?
For the 100th time. The money is in Tennessee State Bank in the escrow account.
And you also said as soon as you received all the bills, you would close it. And you did tell her on more than one occasion you would send her that money, but you didn't.
And they turned the water on in my name again in October. Did you know that?
Ms. Jones,
No.
did you return the money as requested?
No.
Thank you.
And the bills still haven't stopped coming in.
Does the commission have questions for this witness? Apparently so. Well, we'll
Without
start, I guess we can start, work our way around.
Okay, Liza.
Go ahead.
With regards to the occupancy of the property at the time the contract was terminated, I would say for lack of a better phrase, how many units were occupied?
I think at that time we probably had 6 occupants.
Ms. Goodstein's testimony said 6, so 6 being the case, what?
Commissioner Northern, we're having a problem hearing over here, plus we're recording this in addition to videoing it. So for the video, we need everybody to remember to continue to speak loudly and into the microphone.
What was the average amount of the deposits on each tenant?
Security deposit was $500.
Okay, with 6 tenants, your total then would be 3,000?
3,000.
But the testimony has been that there was 4,100 in the account?
I think we're confused on properties. The 4,100 is the Snider property.
Snider property.
The Goodstein property had total $7,874.89.
So you were only holding deposits for units that were occupied. There were no vacated tenants' money being held. Is Sevier County subject to the Tennessee landlord-tenant law?
Yes.
And with regards to that and the security deposits, are you aware that you're only supposed to use those funds to offset repairs unless there are other related charges?
Yes. The tenants were still in the property at the time, and my question to Mrs. Goodstein was, in one of her emails, she said, give all the money back to the tenants, the last month's rent, security deposit, and everything. And that's when I wrote her back and said, explain everything. I think her statement was, give everything back to the tenants. And I sent her an email back and said,
She can testify from her recollection about a conversation with Ms. Goodstein.
and I said, will you please send me a letter signed by you and your husband telling me exactly what you want refunded to the tenants, because they had been back and forth about stuff.
On your report to Ms. Goodstein, there was reference to check being redeposited.
Yes.
Did she authorize you to deposit her funds into that account?
It was redeposited back into her owner's account to cover the HVAC unit that was being replaced.
Did it have her signature?
It didn't have to be. It just had to be voided and then credited back in the accounting system.
So she never received
She never received the check.
And
It was
never-
voided and then credited back to her account.
So it was actually a credit and not a check presented to the bank for
Right.
revenue.
Right. So the money actually never came out of the account, it was credited back. But it was because of the HVAC unit that was being repaired. And there was a discussion on whether or not it could be replaced or repaired, or we could take one from one of the units that was vacant and switch it over to the other unit, because she didn't want to spend any more money than she had to at that time.
Ms. Goodstein testified that she never received copies of invoices for repair items to her property. Your testimony earlier was that you did send copies of invoices to
Yes.
owners and that they were available online.
They were.
Did she ever request copies? Were they available to her?
They were available to her.
And one other question, and this was there ever a complaint filed against either Smoky Mountain Investments or the realty store?
Mr. Leedy has made multiple anonymous complaints against me.
With regards to these two particular owners that we're dealing with today, did either of them ever file a complaint against Great Smoky Investments or the realty store?
Just as what we're dealing with today,
So they were both filed against you personally?
I guess.
The reason I ask is the realty store is a corporation.
Right.
I'm assuming that there are other owners involved?
There's the realty store, the original realty store. I ended up with ownership in a lawsuit with Mr. Leedy in, I think it was 2009, is when that lawsuit closed. I'm not sure the exact date. I think it was 2009.
But you're currently doing business as Great Smoky Investments.
Yes.
Is that a corporation?
It is a corporation, however, it is dissolved. According to my attorney, it's still a corporation even though it is dissolved by the state. It's still a corporation.
Are you the majority stockholder in that corporation?
Yes.
Thank you.
My question, do you adjust liability and property casualty claims for the owners of that property?
Do I do what, please?
Adjust the claims? Like if somebody falls, do you adjust the claim or do you turn it over to their insurance?
I don't adjust the claim
Well, why would you hold money?
because I end up getting sued. I'm
Do
usually
you not have
the one
insurance
that-
for your operation?
Yes.
Well, why? I can't understand why you'd hold somebody's deposit over a claim that an insurance company should settle. I don't understand that.
Well, I understand your question.
You do understand it?
I do understand
Okay.
your question.
See, it seems like that's going beyond the scope of just be able to hold somebody's money.
No, I mean, the money's not in my account. I can't spend it. It's sitting in the escrow account. That's,
But it has nothing to do with the claim.
well, but you never, when someone files a suit, generally, my experience has been, I get named in the lawsuit, which means I have to hire an attorney.
Well, it has nothing to do with this.
Well, it does if I'm the one that's getting
Your
sued.
insurance will take care of you. Your liability.
Insurance doesn't seem to be doing as well as it. They're usually looking for a reason to get out of it.
So if it was $1 million claim, you'd go back on the property owner and make them pay that? Is that what you're saying?
Well, I would initially ask my attorney to have them enjoined in the lawsuit.
You know, to pay out the claim, you've got to be liable.
That's true.
That's all I got.
But also the attorney, you and I both know how attorneys work.
That's the, I know I have a son.
So everybody gets sued.
Good afternoon, Ms. Jones. Austin McMullen.
Yes, sir.
Who is Heather Hill?
She was an assistant at the office.
Okay, and she worked for you?
Yes, sir.
Okay, that's all I have. Thank you.
Good afternoon. I'm Michelle Haynes, and I have a few kind of broad questions.
Okay.
How many units do you manage? And are they commercial and residential? Or just all residential?
They're all residential.
Okay.
Well, they're zoned, I have two that are zoned commercial.
That's all right, if you rent them as residential.
they're rented
So
as
how many
residential.
units altogether, would you say?
100.
100 units? Okay. And how many escrow accounts do you have?
There's a copy of all of them in the Tennessee Real Estate Commission file.
Well, I mean, I'm also in property management.
Okay.
I mean, so you have an escrow account. Just kind of explain to me your escrow
okay.
accounts and what you have. I guess
Okay.
I'm not trying to be.
Oh, that's fine. I don't have a problem with it. I have the escrow account for the security deposits, and then I have an escrow account that checks that are written to like owners and for vendors and so forth. They all come out of this one operating escrow account.
So that's an operating escrow account.
Right, that pays out to the owners and to the vendors.
Okay.
So the owners that get paper checks get it out of that account. Any paper checks come out of that account.
So when they're receiving these accounting, within that account, then they each have their own individual accounts that's what your accounting
Right.
method brings up.
Right.
Do you have an in-house accountant, or do you have a separate accountant
I
that?
have a separate accountant.
Okay, does he oversee some of this, or is this all done in your office?
The majority of it's done in the office, and then I refer to him when I have questions.
Yeah, the bookkeeping part, is that what,
Right.
like Heather and
Right.
their bookkeepers?
But
Okay.
after the deal with Mr. Leedy, I'm the only one that signs checks.
Okay.
Now, all the deposits go into one deposit account, and then the money is transferred to, like the security deposits is transferred to
Yep.
the security deposits, and then the operating escrow. And then, since we do online payments, and you have all the hacking problems that they're having these days.
Wow,
there's-
that's intricate. Online payments, too.
Yeah.
Wow.
Well, see, we have tenants that pay online, and then we have owners that get direct deposit. So anything that's done online is done through this one account, so that it's easier to track
Right.
the incoming payments and then the outgoing payments.
And you have 90 owners, is what you said a minute ago?
Yeah,
Approximately.
about-
You don't have to give me
90
a
of them.
90.
And most of them have been with me since the day they bought their properties.
Okay. And I was looking at your website, and you talk about your education, and your firm is, tell me about your education. Your education, yourself,
In what respect?
and property management.
I've taken the classes through, I'm brain dead.
I know, it's been a long day.
Good Lord.
And it may be a question for Eve, because she may have those on file, but
Not everything actually comes into y'all for some reason. I've taken all of the classes to qualify for the one that's offered through,
Okay.
May I have your attention, please? About to rebuild the sprinkler system on the 7th floor. If you hear alarms in the next few minutes, please disregard. Make another announcement. Thank you.
And maybe we won't get wet.
Okay. We need umbrellas.
They want to be safe.
Okay, back to your education.
I was trying to think. That's it. Thank you so much. The one for residential.
You did the Institute for Real Estate Management. Okay, tell me about that real quick. You did how many
It was a
courses and how many
1 week.
hours?
It was actually I took everything in the 1 week class.
Okay.
And I already had a CCIM, so that gave me some credit
Okay.
towards
You have a
that
CCIM.
degree.
And what about the people in your office? Do they have education? Have they been sent to classes like, accounting classes, or are they just, you just oversee them and tell them this is how it needs to be done?
I oversee them.
Okay, which, I mean, that's all legal and fine. And when you first heard about the complaint, I'm just curious, why didn't you respond?
At that point, I was going through, Mr. Levy, God, my life has been a nightmare. If you go back through all of the vandalism and the complaints that he's filed with the Department of Labor, the stabbing the tires, breaking the windows, stealing my car.
Well, I'm talking about the complaint to the commission.
I was just overwhelmed with other things.
Okay.
And then immediately, on August the 1st of 2011, we were supposed to have a court hearing, and it's always a month, it starts about a month to 2 months before the court hearing for him, which makes me worry what's going to happen next, because his next court hearing is December the 11th. August the 1st, the water supply line to my house miraculously came undone and did over $65,000 worth of damage to my house. It flooded the entire house. Have you ever just been so overwhelmed?
Devastated, yeah.
Don't know what to, I mean, everything's
So
just...
you just had a lot of personal things happening that you just weren't able to respond?
I just was not able to. I was like, I just can't deal with one more thing right now. Because you're dealing with the insurance company, you're dealing with trying to get all that stuff out, and the mold was growing, and it was just the biggest god-awful mess you've ever seen, and it's still not resolved.
Mr. Levy?
Levy, L-E-E-D-Y.
He was also a management broker, and did he go into business for himself someplace else?
Yes.
Is he still managing property somewhere else?
He's working with Tisha Morris and Bettina Koopman and Realty Plus, Renee Weiss, which is where Ms. Goodstein's property is managed now.
So, because I thought that his license was...
It was.
Taken away from him.
It was.
So, okay, he's working in other capacities then.
I'm not positive.
Okay. I guess that's all I have.
Ms. Jones?
Yes, sir.
As I understand it, I'm Bear Stevenson, Real Estate Commissioner. As I understand it, you're these 100 or so properties now that you're managing. You're operating under Realty Store?
Great Smoky Investments.
Smoky Mountain Investments, okay.
No, sir, there's no mountains in it.
Okay.
Great Smoky Investments.
Great Smoky Investments.
Uh-huh.
And you've testified that the judgments against you and the deposits you're holding, they're not in that account. They're in First State Bank somewhere.
They're in Tennessee State Bank.
I mean, Tennessee State Bank. They're in Tennessee State
Your
Bank.
office actually has a copy of the bank statement where the money is. The last inspection, I gave the auditor copies of the bank statements.
I'd like to ask you, roughly how much monies do you have in this mysterious account that's not the escrow account or it's not in the name of Great Smoky Investments? How much monies do you have?
It is in the name of Great Smoky Investments.
But it's a separate account.
It's a separate account.
How much money is in there?
It's money that's in, you have a couple of different issues in there. $21,000 is in one account and $25,000 is in the other.
Are those the only two accounts?
Those are the two with funds that are
business accounts relating to the Great Smoky Investments.
They're in escrow account. It's an escrow account at Tennessee State Bank.
But are those monies that are in there in regards to the Sniders and to Miss Goldstein?
Goodstein.
Goodstein?
Ms. Goodstein's money is $7,000, $874.89.
Why don't you pay it to them?
Well, it can be paid to her now, in my opinion, and I don't have a problem with paying it to her now. I was waiting until the year was up with the tenant to make sure that I didn't get sued.
Okay.
But now that the year's up, there's no problem with releasing the funds.
Okay, let's pick up right there. I'm Janet DeChara.
Yes, ma'am.
With the accident that you were afraid you were going to get sued over, when did that happen?
It happened in right before he moved.
Which was when?
I don't remember the exact date.
What
and
month?
I did not bring all of that information with me.
What month was it?
Attention, please. Now done filling the 7th floor sprinkler system. There will be no more alarms today. Thank you.
What month was that? Do you have any idea?
Truthfully, at this point, no. I don't. I'm thinking it was June, is what I'm thinking, because it was right at the time that I was trying to close everything out with Ms. Goodstein, and then well, wait, I can tell you when it was. It was in June, the end of June, because he moved out the 1st of July. So it was the end of June.
Okay, and you had already stopped managing her properties at that time?
June the 16th, I sent out information to her that I was going to that I was canceling the contract with her.
So if you were no longer managing the properties, then why would you have held money on a fall that happened after you quit managing those properties?
I don't know the exact date of the fall. All I know is the date that he moved out, which was the end of June, 1st of July. He notified me of the fall.
You stated you stopped doing maintenance on the properties because you were no longer taking care of them,
No,
which is what caused the fall.
I stopped doing maintenance on the property because Ross Gray sent me a letter that told me to stop all maintenance repairs and don't spend any money on the property. Ms. Goodstein sent me an email that said stop all maintenance on the property, which I asked for clarification on. That was stopped back in 2010 was only absolute necessities. 2011, she wanted to stop everything, and that's when I asked for clarification because she wanted to stop everything. And what does everything mean? Because it was a 10-unit apartment complex. It had a dumpster for the trash, haul off, and we had utilities on all of the properties, and I wanted something in writing from her because mold grows really bad in some of these properties, and that one wasn't built the best in the world. So it has a lot of issues in that property.
Okay, I've got just a couple more questions. One was with Mrs. Goodstein. There's a question about whether she received her money or not. You say you mailed, the check was in the mail. She says she never got checks. Can canceled checks not be pulled to prove that she got the money?
Absolutely. Which is what I did to her with her on several occasions, especially when she was going through chemo. I would have to pull copies of checks and get front and backs of them and send them to her.
Do we have copies of any of that?
No.
But you do?
I can get it. I mean, if I need to. There's not a big deal to go to the bank and say, because we can print out every check that was written to Ms. Goodstein. I can print a list of it out and then request copies of them.
But you do admit you have money that belongs to the Sniders and Ms. Goodstein.
$7,874.89 of Ms. Goodstein's, And on Mr. Snider, I would have to adjudicate it because I had $4,100, and then they got $1,899, I think it was. I haven't separated it out yet. But it's all held in that account.
Let me start with Snider's first. I get the sense that you were shuffling money at Tennessee State Bank to keep the Sniders from collecting on the judgment. Did I state that correctly?
Not overtly. That wasn't my intention. When I changed over to Great Smoky Investments, I just moved all of the money but about $2,500 because I still had a couple of checks left to clear. And so the money was left there to clear those checks. And then the garnishment, I think, or whatever you call it, came into Tennessee State Bank. And I got notice of that.
So the garnishment hit before those checks cleared?
Yes, and so I was sending out cashier's checks to solve that problem.
Well, I guess the garnishment was for the full amount of the judgment. Is that?
Yes.
Did you consider transferring money back in to satisfy the judgment?
No, because I was, in hindsight, possibly that would have been a better thing to do. But in my opinion, the judgment was erroneous, and that's another issue, as we both know. So.
Okay, let me talk about Ms. Goodstein for just a second.
Okay.
She referenced, or I asked her a question about Ross Gray. And she said that there was a lawsuit that she wasn't aware of, and the court ordered Ross Gray to be paid on behalf of some tenants $2,400.
Fine.
Is that correct?
She did know about it. There were 4 apartments rented to some construction workers that were working on Bell Island. And when they left, there was a lot of damage to the property. One of them took a BB gun and shot up everything.
That's okay.
Well,
really, that part of it, I'm not interested in.
That part you don't care about? Okay.
So here's my question. You have an operating account and an escrow account. Is that correct?
Right.
So would those deposits have been in the operating account or the escrow account?
The escrow account.
They show that it appears to me that they were paid out of the operating account.
Because the money was moved from the escrow account into the operating account.
And I would think that would show up on this owner bank activity. The deposits should show up.
The deposits do show up.
I don't see the 20.
As well as, you don't have all of the, you don't have the whole picture. You don't have part of the picture.
When would it be transferred over? After the court said you had to give the deposit back?
Yes. Because
wouldn't that be about the same time you gave the deposit back, is my point. That's why I don't see the deposit.
Right. It should be down there. The reason the court ordered the money to be given back was because the repairs were never made. The repairs were never made because Ms. Goodstein would not approve them. That's the reason she lost the case.
To me, I just need to know that the money got into the operating account after the court ordered.
It did.
That Mr. Ross be reimbursed.
It did.
I just don't see that on the back. I just don't see that on here. That's my question.
Okay. It all got transferred and paid out to Mr. Gray, so that there was.
I mean, I could make a case based on this that you just paid Mr. Gray out of your operating account and not the escrow account.
Well, it's transferred from one to the other, so.
And my case wouldn't be worth a darn if I could see where the deposit occurred, and I don't see that. That's my question.
I understand your question.
Thank you.
In all of these bad times you've had, and when you decided not to give folks their money back that belongs to them, and you've got 2 or 3 escrow accounts floating around, and you think the judges are crooked, the lawyers are crooked.
Speak up. Speak up. Speak up.
Can you not hear me?
Speak up for the record.
Did you ever turn in and when you thought that you might have a lawsuit, did you notify your E&O carrier?
Actually, no.
That's interesting.
I probably, in hindsight, should have, because I have the maximum, I carried the maximum E&O coverage. I carried the property and still have the property management
But you
coverage
take
and all the
other
rest
people's
of it.
money, put it in an escrow account, supposedly, switch banks with it, because you think there might be a lawsuit.
There,
Sounds to me like you're the judge
no,
in making a decision where the money's gone. And that's not what the law says. You were, I don't have any more questions. Yes, I got, I believe this morning when we're early, you ever been before this commission before on a complaint?
it was filed
Have you
against
personally
me.
been here before
That's-
this commission before
No,
on a complaint?
that's,
But
not
I
that I
believe it was,
recall.
pardon?
Not that I recall.
I think you'd remember it. You remember a lot of
called
other,
as a
you can
witness.
remember where you put that money.
So you have a copy of it?
Ma'am, I'm looking here at this statement.
Okay.
You can print me out a statement, and it'll show the profit and how much the loss and that and the other. But if you don't send a check, they won't balance, they won't match. You gotta fund this account with a check or cash or some way.
That's true.
And you didn't do that. You got my emails, the checks in the mail, gonna do this, gonna do that. You haven't done anything but put it in an escrow account. Now, I believe this morning you all stated there had been under either 5 complaints been filed against.
7.
One company was 5 and one was 7. I believe it's been 12 in all, isn't it? Wasn't that stated earlier?
7 against the realty store and Judy Jones. There were probably, let's see.
5 against the other?
7 personal.
Personal ones.
Okay. And you, principal broker, the buck stops here for us, I'm concerned. Principal broker, that's what the principal broker is responsible for managing those accounts. I'm third.
Your Honor, I have 2 quick questions. One to Ms. Jones. Do you have the funds to pay the Sniders and the Goodsteins what is due them in First State Bank?
In
Tennessee State Bank, I'm sorry. Why haven't you paid them?
Ms. Goodstein's can be paid now. There's no problem with paying Ms. Goodstein's. I was waiting until this episode was over.
Anything further from the commission?
Those workers that were staying at the unit that tore it up, did you know the contractor that rented that unit?
Did I personally know
Yeah.
him? No.
Did you not think about calling the law and trying
We
to collect
did.
from them?
We did.
What happened?
They didn't think that it was worth going to.
That's all I got.
Trying to get, I mean, I have several before them right now on repairs, and you can't even get them to court.
Let's see.
I have 2 quick questions. How often do you do inspections of your units?
It depends on the owner. I have some owners that want them done fairly often, and if there are pets in the property, I do drive-bys about every 2 months and view the outside of the property, and then interior inspections are done based on the contract with the owner and the agreement with the owner.
And second question, how much money do you think, goes through your operating account on rentals a year? So really, how much money do you think you collect in rent a year? Couple $100,000?
But I don't know.
I mean, okay, how much do you collect a month, do you think, in your rental?
Probably, in a month's time frame, probably $50,000 maybe.
Yeah, so we can multiply that easy enough. Okay.
I would think. Kind of depends. Right now, I've got 10 units vacant.
Yeah, I know vacancy, that's why I was just getting an average,
So,
that's all.
I don't have a, and then you've got some slow pays, and you've got some
Oh, yeah.
people that, It's one of
Ms.
those
Ryan?
I
fluctuating
have some
things.
cross-examination based on her testimony.
Okay.
Ms. Jones, you testified that Ms. Goodstein never told you where to give the money. Is that what you said earlier?
Do what, please?
That Ms. Goodstein never told you where to pay the tenants' money and who to pay it to? That's what you said? You said you asked her for clarification, and you said that she never responded to you about that?
I asked her to send me a signed letter that was signed by she and her husband, giving me permission and telling me what to do with it.
But in June 19th of 2011, she said, this is in an email you provided to me, you have been instructed to deal with my attorney and you refuse. I have been told my money for April and May is in the mail for months now. I have instructed to release all to my representative and you refuse. Did you release it to the attorney?
She fired Ross Gray shortly after that.
On June the 20th of 2011, she says to you, I will not talk to you about this anymore. Everyone has sealed the statements, and no, you didn't send me what you stated you paid the owner. You were never told to give any money back to tenants. I have copied not only my attorneys, but the bank also. She further says, please deal with my attorney and do not contact me. Did you do that?
She fired Mr. Gray shortly thereafter.
On July 1st, she says, I'm attempting to give one last time to do the right thing. My having to file a lawsuit and the horrific amount of money, as you know, is not what I want. I have consulted with the family. We are out of the mind that we have no choice to move forward. If you do not send me the outstanding monies owed to me and to the tenants of Oak Ridge by Wednesday, July 6, 2011, to me here at my address in Miami. And then she gave her address. Didn't she tell you that?
All of the bills were not in by July the 6th.
Ms. Jones, you said that she never told you where to send the money, and that the only thing she told you to do was return
I don't
it.
believe that I said that.
Yes, you did.
I disagree with you, but that's fine.
Now, Ms. Jones, you were audited in July of this year, right?
Yes.
And you told the auditor, at least this is the form, that you were going to apply for escrow waivers. Did you apply for escrow waivers?
And I sent him a letter, if you probably don't have that.
No.
That the waiver statement was incorrect, and therefore I couldn't sign it, because if you read your waiver statement, it needs to be corrected.
And additionally, it says, the firm, and you signed this, so you've read this, firm will open separate account to move security deposits to, will send listing of the security deposits held, and will do so by September 1st, 2012. Did you do that?
Yes, I did.
How is it we don't have documents for
I
that?
don't know why you don't have it, but you should have.
And also,
because it was emailed to him.
you also said earlier that you had 2 escrow accounts, right, in the bank? But you really have
copies of all of the escrow accounts.
You have more than 2. Isn't that right?
Yes, you have copies of every escrow account that I have. It's all all provided to Mr. Kidd.
And you have, in my count here, you have 3 at Smart Bank.
Okay.
And 2 at Tennessee State Bank.
Okay.
Is that right? How come you didn't tell them about the ones at Smart Bank?
The 2 at Tennessee State Bank are the ones that we use right now are the ones at Smart Bank. I've explained the number of accounts that we have.
Your ending,
I said I had multiple ones.
In your ending balance of the statement provided in this audit of 6/29/2012, in one Smart Bank account, you had $232,924.
Okay.
In another account with Smart Balance, you had an account balance of $2,094. In the third one by Smart Bank, you had a balance of $25,186.50, and then the 2 you referred to earlier with Tennessee State Bank of $22,824.61 and $25,871.95. These are documents that you have in your escrow accounts, right?
Yes, that I gave Mr. Kidd copies of and that I referenced when I was speaking with Mrs. Haynes.
Yeah, and did you
we were talking about, did I name the bank? No, absolutely. I don't think I did. I apologize.
You just named 2 accounts, ma'am. You just said the deposits in those 2 accounts.
When I was speaking with Mrs. Haynes, when we were discussing the accounts, I named each one of them.
You did.
And then I named...
You named 2 accounts.
I said we had the account,
the escrow account was, the $63,000 was sent to Mr. Kidd when he wanted the escrow separated from the other escrow.
You have 5 escrow accounts.
Yes.
You didn't mention the other 3 earlier in your testimony.
They're all right there in your...
I understand.
That you have.
But you didn't mention them when you were asked about them earlier in your testimony, did you?
I mentioned each one of them. You have copies of everything that I have.
I have nothing further.
Well, I want to ask Robin a question. You say those other 3 are escrow accounts at that other bank?
Well, Ms. Ryan is not able to provide.
But I'll be happy to put on Ms. Maxwell if you want to ask her about the documents.
Okay, Ms. Maxwell,
She has to...
okay, never mind. That's all right.
That's Ms. Jones.
That's all right. Are those other 3 escrow accounts at the other bank that we didn't know about? We just knew about them?
Those are the 3 that you and I were just talking about that had the one where I send the checks out on.
Those aren't at First State Bank?
They're at Smart Bank.
Okay, Smart Bank's the first time I've heard about Smart Bank.
Okay. I forgot to name the bank. I
That's
apologize.
okay.
But at any rate, they're all 3 right there. And they're all identified as escrow accounts.
Okay, so two you mentioned, you said you had one with $25,000 and one with $22,000 were the only 2 you actually mentioned. So that was at...
And then
that was at which bank?
Tennessee State Bank.
Tennessee State Bank.
And then the other is, at Smart Bank, you have the regular, where the security deposits are for the people, and then where the online payments are made, and then where all the deposits are made.
Just a quick follow-up.
Oh, sure.
Ms. Jones, you indicated that you insinuated that you were going to file some kind of legal action against the Sniders?
Yes.
In what jurisdiction?
In federal court.
Federal court. Is that because you don't really take much from the orders delivered by the Sevier County Civil Court?
Right.
What is it you're suing for?
I would rather not have that on record at this point. My attorney and I have discussed it, and it would be better not to have it disclosed here at this time.
I mean, I'm not the smartest man in the world, but you say you have the money to make the Sniders and the Goodsteins go away.
It's in the Tennessee State Bank.
And you don't pay them. Why? I've asked you before. That blows my mind.
Well, Ms. Goodstein, like I said, I thought that the lawsuit was going to come through because of the person that we were dealing with. Luckily, she did not sue. And I was concerned about having the money to pay the attorneys. It's not my responsibility if the lawsuit comes through. Ms. Goodstein's responsible for the attorney's fees, not me.
Sure was your responsibility to plead the money or do something with it, you not the judge.
Within 21 days.
That's true.
Do you understand what this commission does?
Possibly I need to be enlightened on something.
No, I don't want to tell you. I'm just asking, what is your understanding of what we do and why you're here?
Why do you not want to tell me?
No, I don't have a reason not to tell you. I'm just wanting to know why you're here and what you think we do. Maybe you have a misunderstanding. I mean,
I'm not sure what we're talking about.
Okay, that's all right.
I'm not sure what.
And I was just wondering what your understanding of what is going on here and what we're doing. Okay, that's all right.
You've waited patiently.
What? So I'm still trying to understand these bank accounts. Gray Smoky Investments operating account. What bank do you use?
For
when you print an owner's bank activity, which bank is that?
Smart Bank.
Okay, and Ms. Goodstein's money's at Tennessee State Bank?
Tennessee State Bank.
But you have 3 other escrow accounts at Smart Bank?
Yes.
So my question is, why do you have so many escrow accounts?
protection of the money is what is in my mind. Well, the security deposits need to be in a separate one, but I don't want the online banking to have, if someone hacks the online banking, to get the other money, to be able to attach the other money. I mean, you're talking, there's a considerable sum of money sitting there, and it could be at risk if someone were to hack the account.
Both those banks are FDIC insured, right?
They are, but you're still, it's a nightmare, and you and I both know that.
Well, I don't know about real estate companies that have 5 escrow accounts. I really don't.
Okay.
It makes no sense to me, unless you can tell me.
It makes it easier for me to keep up with the money that's coming in and going out.
Okay, so back to Ross Gray. That $2,400 I'd like to see deposited, it would have been deposited into Smart Bank, right?
Right.
And it would come from Tennessee State Bank.
What month was that?
Oh, I've got it. It's here. You paid Ross Gray $2,400 in August of 2010.
2010, it would have been in Smart Bank, probably.
Which would
But I would need to check it to make sure. I don't know for sure. I would need to check it and make sure.
Well, if the escrow account and the operating account were in the same bank, you would just do electronic transfer.
Right.
And it should show up on it, shouldn't it? I mean, that still baffles me that it's not on here.
It wouldn't necessarily show up on that owner's activity, I don't believe.
It shows the payment, refund of deposits.
I'd have to look at it and see how it
All
shows.
right, thank you.
Which account would you, escrow account would you take it out of Smart Bank? How would you have decided which account you're going to take it out of? And deposit it into another bank.
Checks are written out of one operating account.
We're talking about escrow accounts, ma'am. We're not talking
Right.
about operating accounts.
It is an operating escrow account.
Such thing.
Sir?
I didn't think there was any such thing as operating escrow.
Well,
The last time I heard of that was from Bob 3 years ago up in Easton.
No, what I mean is, if you've got checks going out, it's like an operating account, and then the escrow account is, but it's escrow money. It's all escrow money. It doesn't belong to me. It belongs to other people. It's not my money.
Tell me you got 230, 50.
On that date.
That's 280, over $300,000 of those folks' money.
On that date, that's what was there.
If possible, I know we've heard a lot of testimony today from a number of people, but if possible, I'd like for you to search your minds and come up with any additional questions of Ms. Jones, and let's go ahead and proceed with this formal hearing.
Any additional questions? Well, we have closing statements unless they choose to waive them. And then we also obviously have deliberations. Do we want to do a break before then, or you all just want to move on?
Everybody need to go. Those of you in the audience, if one of you leave, we continue. If one of us leaves, it stops. So we want to continue on. If you need to go to the restroom, just step out, come back quickly, and we will continue on.
Ms. Jones, you can resume your former seat. Closing statements.
Everything is somebody else's fault except for Miss Jones. Everything is something else, considering, for instance, she doesn't exactly tell the truth about what's been going on. She actually has 5 escrow accounts, not 2, as she was discussing earlier. Everything is a problem that has somebody else and not her. She keeps people's money to protect herself. She didn't put her clients first. She didn't timely account for monies that belong to others. She's a real risk out there. The These are two people that are complaining. We have no idea what else is going on, but we do know that there's a judgment against her. We also know that she's still holding monies owed to Ms. Goodstein, even though it's been a year since her contract was terminated. I don't understand how Ms. Jones thinks she is the law. I suggest that she is in violation of many sections of the code in 312. She's willful, she's made willful misrepresentations, she has fraudulent acts, she's violated other rules of this commission, and she has refused to timely address the money belonging to others. I'm asking you all today, after we see the seriousness of this and her inability to tell the truth or be honest, I'm asking you to revoke her license, to charge her with all the court costs in this matter, and if appropriate, also assess her a civil penalty. Thank you.
Ms. Jones, would you like to make a closing statement?
Thank you.
Okay. I will need to charge the commission. Do you have any specific charging information you'd like to provide?
I do have proposed findings of facts and
Okay, if you want to go ahead and pass those out. Would you, well, that's fine. Go ahead and pass them out.
And I'd like to remind the commission that as we proceed forward with our deliberations, that we take the notice of hearing and charges that we were given this morning and not have one working off of that and the other commissioner working off what we have just been handed, because it gets rather confusing, which took place in another matter similar as this about a year ago. So I'd like to just point that out to the commissioners.
Okay, before, yes. Ms. Jones, do you not wish to stay for the deliberations? Okay. I will proceed with the charge to the commission. This matter will now be referred to the commission for deliberation. Your decision must be made from the evidence that was presented at the hearing, which will consist of sworn testimony of witnesses and exhibits marked into evidence. It is the prerogative of the commission to determine the credibility of each witness and the weight to give the testimony of each witness. Statement of counsel, and that would include statements of the respondent in the capacity of representing herself, that are made during the course of the proceedings are not to be considered as evidence, but only as argument to convince you to decide with their position. You must not infer from any of my rulings or instructions that I hold any view or opinion for or against any party in this matter. None of my remarks have been intended to indicate an opinion regarding the facts or what your decision should be. The Administrative Procedures Act specifically requires your order to contain findings of fact and conclusions of law and the policy reason for your decision. In making your decision, you must consider the evidence in light of your own reason, training, experience, expertise, and common sense. Your findings of fact should be based solely upon the evidence presented before you in this hearing. It is your duty to determine the credibility and weight to be given to the competent evidence presented by each witness. Under the law, it is presumed that all witnesses tell the truth. If there is conflict in the testimony between the witnesses, you must first try to reconcile these conflicts whenever possible. If it is not possible to reconcile conflicting testimony, you must make the determination as to which witness is found to be the most credible. Proposed findings of fact and conclusions of law have been provided by the state. You may use this document as a guide to assist you in making your findings, but it is the sole responsibility of the Commission to make your own findings of fact. You should use the guide only after careful consideration and determination that the proposed findings accurately reflect your own independent recollection of the evidence and your own conclusions. The state has alleged that the respondent has violated certain state statutes and rules. The state has the burden of proof in this matter. The respondent does not have the burden of proving that she is innocent of the charges. It is the state's burden to prove its allegations by a preponderance of the evidence, which means that the greater weight of the evidence is in favor of the state. You must limit your inquiry regarding the violations of statutes and rules to those violations alleged in the state's notice of charges. Once you have made your findings of fact and decide whether or not the respondent has committed the acts or omissions alleged by the state, you must decide if the respondent's alleged acts or omissions constitute a violation of the state statutes or rules. You must then state your conclusions of law. And specifically with regard to the findings of fact and conclusions of law, case law in this area requires very specific findings that are linked to your conclusions of law. So if you, for instance, find that there was a violation of a particular statute or rule, you would have to specify what specific facts you used to make that determination. There needs to be a link between the fact and the law in determining that there was a violation. In the event that this matter should be appealed, that is going to be one of the inquiries that either the chancellor or the appellate court will look at to determine whether or not the decision is substantiated. If you decide that there has been a violation, you must decide what disciplinary action, if any, is appropriate in accordance with your legal authority and the particular aspects of the case. For this purpose, you may consider any evidence that the parties have introduced, for instance, whether the alleged conduct was or is continuing or only a one-time offense. You may revoke, suspend, place on probation, reprimand, assess a penalty, or otherwise discipline a licensee. If you find that the state has carried its burden of proof and you have articulated your findings of fact and conclusions of law, you must state a policy reason for your findings and conclusions which explains why your decision in this matter is appropriate. I can provide additional assistance with the law and the structure of your order. If you have any particular questions about the evidence presented in this matter, you can, by majority vote, go back on leave deliberations and go back on the record and ask any follow-up questions that you may have, which I think at this point would be limited to the executive director, as it appears all of our other witnesses are gone. All motions must be carried by a simple majority of the commission. If there are not any questions at this time, I turn the matter over to you, Mr. Chairman, for deliberations.
Thank you, Judge Summers. This time, in the matter of Judy Jones, docket number 18-116426A, in our proceedings, we need to go through our findings of fact, what we have heard testimony of today, and I would, if this time, if I could ask that our Commissioner, Mr. Austin McMullen, if he would sort of lead us through, since I as a chair can't, but if you would, Mr. McMullen, for the rest of us, just sort of go through each one of these.
Mr. Chairman, I guess we need to go through these one by one, but I would, with that in mind, start off with moving that we adopt proposed finding of fact number 1.
Your motion, Commissioner McMullen, was to find that that is true?
Yes.
I have a motion of Commissioner McMullen that the findings of fact number 1 is to be true, seconded by Commissioner Alexander. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I would move that we find that proposed finding of fact number 2 is true.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner DeShaw that number 2 is also true. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I would move that we find that proposed finding of fact number 3 is true.
Number 3 has been moved by Commissioner McMullen to also be true, seconded by Commissioner Northern. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we find that proposed finding of fact number 4 is true.
Second.
Mr. McMullen again has made a motion that number 4 be found true and seconded by Commissioner DeShaw. Any discussion? Hearing none. All in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I would move that we find that proposed finding of fact number 5 is true.
Number 5 has also been made a motion that it's true.
Second.
Seconded by Commissioner DeShaw. Any discussion on number 5? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I would find that I would move that we find that proposed finding of fact number 6 is true.
The motion by Commissioner McMullen and seconded by Commissioner it's been a long day, Commissioner Northern. Any discussion on number 6? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I would move that we find that proposed finding of fact number 7 is true.
Second.
Commissioner McMullen, that number 7 also is true, and Commissioner Alexander seconds that. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I would move that we find that proposed finding of fact number 8 is true.
Commissioner McMullen has made a motion that we also find number 8 is true, and seconded by Commissioner DeShaw. Any discussion on number 8? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I would move that we find that proposed finding of fact number 9 is true.
Second.
Also, number 9 has been made a motion that is true, and seconded by Commissioner DeShaw. Any discussion on number 9? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we find that proposed finding of fact number 10 is true.
Second.
Commissioner McMullen made a motion that number 10 is true, and Commissioner DeShaw second that motion. Any discussion on number 10? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we find that proposed finding of fact number 11 is true.
Motion made by Commissioner McMullen that number 11 is true. Commissioner Alexander second that motion. All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we find that proposed finding of fact number 12 is true.
Second.
Commissioner McMullen makes a motion that number 12 is true, and it's seconded by Commissioner DeShaw. Any discussion?
Yes, sir. My recollection is that the respondent indicated that she did provide a proper management agreement, but it was never acknowledged as having been received.
And my recollection is that we didn't actually ask Ms. Goldstein if she had received it. Maybe we did.
Yeah, we did.
I'm clear that Ms. Goldstein says that she didn't have one, but I also think that it was stated that it had been offered or sent and just not acknowledged that it had been received.
Mr. Chairman, I would withdraw the motion and like to make another motion.
Commissioner DeShaw said she would withdraw her second.
Okay. Mr. Chairman, I move that we find that the respondent and Mrs. Goodstein did not enter into a new written property management agreement.
Second.
Motion has been restated that number 12 be worded to failed to enter into a signed agreement, new property management agreement, and seconded by Commissioner Northern. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt.
If I may, just a suggestion with respect to 13 and 14 together. That's essentially the testimony that was provided by Ms. Goodstein, and I would suggest rather than finding that she made this testimony, taking it a step further and finding that there was a discrepancy and that there was a finding of misappropriation.
Mr. Chairman, I propose that we adopt as true the following finding of fact, that there is a discrepancy in funds relating to Ms. Goldstein's property located at 629 Ridge Road, Sevierville, Tennessee.
If I could, I think you said 629, that's 926. 629 is a typo. The typo here. 629 Ridge Road, Sevierville, Tennessee. You've heard the motions, seconded by Commissioner DeShara. Any discussion on that motion? All in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we find as true the following finding of fact, that there has been a misappropriation of Ms. Goldstein's funds by Ms. Jones charging Ms. Goldstein for property costs that were not related to Ms. Goldstein's property.
Second.
You've heard the motion made by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on that motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt as true proposed finding of fact number 15.
Second.
Number 15 has been entered into a motion that it is true by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Motion, opposed, no. Motion carries.
Mr. Chairman, I move that we adopt as true proposed finding of fact number 16.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner DeShara that number 16 is in fact also true. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I have a few other proposed findings of fact that I wanted to recommend based on what I heard in the testimony and the exhibits that were provided that aren't included in the proposal that we received from the state.
Do you want to make it number 17?
Sure, we can call, well, there are several of these. We can call the first one number 17.
Okay.
Mr. Chairman, I move that we adopt the following proposed finding of fact as true, which would be number 17. Ms. Jones received the Snider complaint on July 28, 2011 through her assistant, Heather Hill, who works in Ms. Jones' office.
Second.
Have a motion and a second. The motion you have heard is by Commissioner McMullen, seconded by Commissioner Northern. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 18. Ms. Jones received the Goodstein complaint on August 5th, 2011.
Second.
You've heard this motion by Commissioner McMullen that Mrs. Jones received the complaint from the Goodsteins on August the 11th?
No, August 5th.
August 5th, 2011. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 19. The Sniders entered into a property management agreement which states that Ms. Jones would submit a monthly statement of all receipts and disbursements no later than the 20th day of the following month, and that Ms. Jones did not comply with this obligation.
Second.
You've heard the motion by Commissioner McMullen and seconded by Commissioner Northern. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 20. As evidenced by Mr. Snider's letter dated October 10, 2009, Mr. Snider requested that Ms. Jones provide certain documents, which she did not provide.
Second.
You've heard this motion. It will be number 20, finding of fact, read into the record by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 21. As evidenced by the testimony of Mr. Snider, a tenant in Mr. and Mrs. Snider's property prepaid rent to Ms. Jones, but Ms. Jones did not turn these funds over to Mr. Snider until he made repeated demands. Finally, these funds were turned over to Mr. and Mrs. Snider approximately 195 days later.
Second.
We have a motion. You've heard it into the record by Commissioner McMullen and seconded by Commissioner DeShara. Is there any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 22. As evidenced by Mr. Snider's October 10, 2009 letter, $4,000 in deposits were owed by Ms. Jones to Mr. and Mrs. Snider, but had not been paid by Ms. Jones.
Motion by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on this motion? All in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 23. As evidenced by the judgment entered by the General Sessions Court of Sevier County, Tennessee, Ms. Jones breached the property management agreement with Mr. and Mrs. Snider.
Second.
Have a motion by Commissioner McMullen. It's been read into the record, and it is seconded by Commissioner Northern. Is there any discussion on this motion? If not, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 24. As evidenced by the judgment entered by the General Sessions Court of Sevier County, Tennessee, Mrs. Jones is not owed a commission by Mr. and Mrs. Snider.
Second.
I have a motion by Commissioner McMullen and seconded by Commissioner DeShara that what Commissioner McMullen read into the record is number 24, finding of fact. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact as number 25. The owner's statement that Ms. Jones sent to Ms. Goodstein for May 2011 indicates a payment to Ms. Goodstein of $1,968.07 in May 2011 and a total of $10,510.09 year-to-date through May 2011. However, Ms. Goodstein did not receive any of these payments.
You've heard finding of fact number 25 that Commissioner McMullen has read into the record and seconded by Commissioner Alexander. Is there any discussion on this motion? Have a question?
I'm not sure I heard testimony to the effect that she did not receive it. Was there some statement made by Ms. Goldstein to that effect?
And she said she had not received anything from Ms. Jones since the April, and Ms. Jones admitted she was holding $7,100 in her account that she owed to Ms. Goldstein in the event of a lawsuit.
Yeah, my recollection was that Ms. Goodstein was talking about that particular document and talked about those numbers and said that she had not received any of those amounts that were showed as being paid to her on those documents.
Any other questions or comments or discussions on this motion? That Ms. Goldstein had not received any of the money, which it was $10,000 something dollars and something cents That motion, Commissioner McMullen?
You want the dollar amounts? The statement said for May there was a payment of $1,968.07, and that the year-to-date figure through the end of May 2011 was $10,510.09.
Okay. Hearing no other discussion or comments, based on the testimony, this is true. All in favor say aye on this motion. Aye. All opposed say no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact number 26. The owner's statement that Ms. Jones sent to Ms. Goodstein, I was trying to remember if it was Gold or Good, Goodstein for April 2011 indicates a payment to Ms. Goodstein of $1,785.58 in April 2011. However, Ms. Goodstein did not receive this payment.
You've heard the motion. Read into the record is also being findings of fact number 26. Do I hear a second on this motion?
Second.
Seconded by Commissioner DeShaw. Any discussion? Hearing none. All in favor say aye.
Can I ask, sorry, clarification, what's the number of
$1,785.58.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact number 27. The owner bank activity that Ms. Jones prepared for Ms. Goodstein for the period January 1, 2010 through October 3, 2010 reflects other payments that were not received by Ms. Goodstein.
You hear the motion at number 27, the finding of fact being read into the record. Do I hear a second on this motion?
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeShaw. Any discussion? Hearing none. All in favor?
Excuse me. I'm not sure Ms. Goodstein indicated that she had not received any payments.
That's what he said.
Yeah, I don't think she said that she didn't receive any, but there were some that she said she did not receive.
Those that are on the ledgers were disputed. That's what you're saying, correct?
Yeah, I'm here. The previous two motions had to do with statements for 2011. This motion has to do with the statement for 2010. And my recollection was that Ms. Goodstein said that she did not receive all of the payments that were indicated on here as being made to her. And I believe that they're indicated on here with the all caps owner's distribution. And she said that she did not receive some of those owner distributions. But there were other ones I think she said she did receive. So this isn't meant to say that she didn't receive any. It's just that she didn't receive all of the ones that are indicated on here.
Okay.
Any other comments on this motion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact number 28. On June 16, 2011, Ms. Jones wrote a letter to Matthew Moreland, a tenant in the property owned by Ms. Goodstein, indicating that an escrow deposit of $750 being held by Ms. Jones would be deposited with the Sevier County General Sessions Court. However, these funds were not paid to the court, nor were they turned over to Ms. Goodstein.
Second.
Motion and a second. The motion with Commissioner McMullen, second by Commissioner Northern. Monies was not paid into the Sevier County General Sessions Court. Any discussion?
This may apply later on, but as far as I can tell, no disputed money related to Ms. Goodstein was ever interpleaded. Not only this piece you're talking about, but other pieces as well. So we can collectively put them in this finding of fact. We can set that aside and do it a little bit later, whichever you think possible.
We can do a separate finding of fact on that if you want.
Okay.
Okay. Any other discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact number 29. Ms. Jones never interpleaded any funds to the Sevier County General Sessions Court.
Second.
I'd like
We have a motion by Commissioner McMullen, seconded by Commissioner Northern. Commissioner Collins, I'm sorry. And discussion.
I'd like to suggest that we be specific in each of the two complaints. So one finding of fact would be that no disputed money involving Ms. Goodstein was ever interpleaded, And then a second, or an additional finding of fact that says, no disputed money related to the Sniders was ever interpleaded.
Okay, Mr. Chairman, I withdraw the motion.
Commissioner
I
Collins
heard Mr.
withdraws his
Collins'
second.
yeah. Mr. Chairman, I move that we adopt the following proposed finding of fact number 29. Ms. Jones never interpleaded any funds to the Sevier County General Sessions Court relating to Ms. Goodstein.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner DeShaw. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact number 30. Ms. Jones never interpleaded any funds to the Sevier County General Sessions Court relating to Mr. and Mrs. Snider.
You've heard the motion by Commissioner McMullen and seconded by Commissioner DeShaw. Any discussion? All in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact number 31. Ms. Jones is holding funds in escrow that are owed to Mr. and Mrs. Snider, but Ms. Jones has refused to turn over these funds to Mr. and Mrs. Snider.
Second.
You've heard the motion by Commissioner McMullen about the funds being held for each of these individuals, seconded by Commissioner DeShaw. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following proposed finding of fact number 32. Ms. Jones is holding funds in escrow that are owed to Ms. Goodstein, but Ms. Jones has refused to turn over these funds to Ms. Goodstein.
Second.
Have a motion by Commissioner McMullen. You've heard the motion. It's been seconded by Commissioner DeShaw. Any discussion? Hearing none, all in favor say aye. Aye. All opposed, no. Motion carries.
Those are all the findings of fact that I have.
Sure it's not.
Having heard these findings of fact, it is now our charge to... Yes, Commissioner Alexander.
Mr. Austin, what about the 5?
I'm sorry?
What about the escrow accounts, the 3 escrow accounts that we were not made aware of? Don't you think that ought to be in that, in the finding of facts? The lady only...
money.
But
only indicated that she had 2, but on other examinations indicated that she had 3 more. She actually has 5 escrow accounts.
We can do that.
I'm not aware of any law that says that she can't have as many as she wants.
That's not the problem where I'm coming from, Isaac. I think you can have any amount you want to, but this commission was led to believe that she only had 2.
Yeah, I had a direct question. How many escrow accounts do you have? And she told me 2.
How many more stacked out there? See, there was 10. The two accounts that she's wanted to talk about had less than $50,000 in the 2. One of them had 20-something, both of them had 20-something. But then you pop up here and there's another that's got $230,000 in it. That's somebody else's money.
I have one comment and a question to our judge. As far as what was before us today and the issues pertaining to the Sniders and the Goodsteins, is this relevant, Your Honor, to go here?
It would be relevant with respect to a finding of credibility, and if you found that her lack of candor today bore on her credibility, then I think that that would be appropriate. And might I suggest that maybe we phrase a finding of fact in this way, that she has 5, only 2 of which were disclosed upon questioning from the commission, and maybe including your conclusions of law, that her failure to disclose all 5 reflected on her credibility and her candor with the commission.
I can see that disappearing right quick.
Mr. Chairman, I move that we make the following proposed finding of fact number 33. Ms. Jones initially testified that she had 2 escrow accounts. However, upon further examination, she later admitted that she actually had 3 previously undisclosed escrow accounts.
We have a motion by Commissioner McMullen. You've heard the motion. Do I hear a second?
I'll second that motion.
Commissioner Alexander seconds the motion. Any discussion based on the testimony and your recollection? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
One other thing I'd like to ask if we could say, she was using the escrow as an operating fund, and that's clearly not operating account.
I think what she was doing is paying rents.
I know, but she called it her escrow operating account.
Well, I can see how she would think of it that way. I don't see that as a real big problem. But I don't know. What do you think, Isaac?
I understood her process to be moving money from the security account to her operating account, and she termed it as the operating escrow account. But I don't see that as being an issue because it's not unusual that you would do that for the sake of one single trail of funds.
I thought escrow funds were funds of other people.
The terminology is incorrect. I agree with you on that.
Well, in a way it is. It's their rents, the way I understood it. So it is the funds of other people, and then she is paying the bills, and I see how she thinks that way.
I understand that too.
And I don't see that as a real big problem.
Well, but
I'd like to see how it's actually titled at the bank.
Well, not only how it's actually titled, but how is she actually using it? If it's truly security deposits, then why is she moving that to her operating account to pay monthly bills? Her security deposits should be refunds back to the tenant or to the seller.
These were forfeitures
well,
that came out of security, paid to the operating account that was then dispersed to the owner. That's not unusual.
No, but that's not what she said. When John was asking her a question about something, she referred back to that security. She transferred it from the security account to the operating account.
Security for an escrow account. It's security.
I got the impression she was using her escrow account to pay her expenses from the rent. That's what she kept calling it, her operating account.
Well, when I questioned her on it, I said, is this where you've got your different accounts for your individuals, your owners? And she said yes. So in this, she had, maybe she's got John Doe owner that has $5,000 in rents, and Smith owes, got $10,000 in rents, and that's all in that account. And we probably should have asked her, do you pay any of your personal expenses out of this account, or is it all for rentals? But we didn't. And I don't know how we'd know unless we just examined it.
I do understand your concern about the terminology. It's just that I don't see the process as being the way the accountant would make it sound like it was being done.
Based on this,
No, I'm not going to make a motion.
any other discussion on the findings of fact portion of our deliberation? Hearing none, let's move on to conclusions of law based on this matter.
Mr. Chairman, we'll ask for a 5-minute break after the judge opines.
We can do the break whenever.
It's 10 after 4.
Are you sure?
Okay, we're going to do a 10-minute break, and I do mean 10 minutes.
As opposed to our normal 10 minutes?
Yeah,
As opposed to our normal 10 minutes, yeah.
Let's continue with our deliberation in the matter of Judy Jones, docket number 18-116426A. And as we continue, we're now in the portion of our deliberations known as the conclusions of law.
Mr. Chairman, if I may?
Yes, ma'am, you may.
When you are considering the conclusions of law, specifically violations, if you should determine that based upon the facts, that there were violations of specific statutes and rules, if you would make reference back to the facts that the alleged violation was based upon, because there are some facts included in your findings of fact that are basically background facts that are not necessarily a violation. So if you would say, based upon this fact, this fact, this fact, this fact, we find this violation, that would provide the necessary linkage.
Okay. Thank you, Your Honor, for helping guide us through this process. At this time, the chair would open the floor for any comments or any statutes, perhaps, that any of the commissioners feel they have been violated in this particular matter.
Mr. Chairman?
Commissioner McMullen.
I move that we find that the following conclusion of law, that the respondent's acts and conduct violate Tennessee Code Annotated Section 62-13-312-B5, which states, the Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of failing within a reasonable time to account for or to remit any monies coming into the licensee's possession which belong to others. And I would further request that this include reference to findings of fact number 13, 14, 19, 21, 22, and 25 through 32.
Second.
We have a motion by Commissioner McMullen pertaining to the statute 62-13-312B, subsection 5, which refers to failing within a reasonable time to account for or to remit any monies coming into licensed possession which belong to others. He read the findings of facts of the numbers, and I would like to, if I could, ask you, Judge Summers, if is it necessary to read all of these findings of facts that have been enumerated into the record?
I think that an order will be created based upon the deliberations, and they will be included. And I think that that will be sufficient so long as those findings are mentioned in the order, and then in addition to the ones that were specifically read into the record, and then there will be linkage in the order that refers back to the specific facts that were used to find that particular violation. I think that's sufficient.
Okay, thank you. You've heard the motion by Commissioner McMullen. Do I hear a second?
Yeah, I got it.
Okay, I'm sorry, Commissioner Collins. Seconded by Commissioner Collins. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Does anybody else have any?
Mr. Chairman, I'd like to ask the court a question. Whenever you were instructing us earlier, you talked about the allegations that the state had made in its complaint. If our findings of fact bear on other statutes that were not specifically mentioned in the complaint, can we still make findings on those? And the reason I ask is because one of the allegations includes violating any provision of this chapter, any rule duly promulgated and adopted, or the terms of any lawful order entered by the Commission.
The respondent is entitled to notice of any charges that are being brought against her. So if it was not included in the notice of hearing and charges, then it cannot be considered today.
Okay. Can I have just 1 second, Mr. Chairman?
Yes, sir, Commissioner McMullen. The state has presented us in their case against Ms. Jones, this Tennessee Code annotated Section 62-13-312B, of which there's subsection 1, 5, 14, and 20 of subsection B. I don't know exactly how to phrase these, but
Mr.
Commissioner
Chairman,
McMillan?
I move that we make the following conclusion of law, that the respondent's acts and conduct constitute violations of Tennessee Code annotated 62-13-312B-20, which states that the Commission has the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by a false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of any conduct, whether of the same or a different character from that herein before specified, which constitutes improper, fraudulent, or dishonest dealings. And for this conclusion, I request that we make reference to findings of fact number 13, 14, 19 through 22, and 25 through 32.
Second.
You've heard this motion, and we have a second by Commissioner DeShara. Is there any discussion on this motion by Commissioner McMillan? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we make the following conclusion of law, that the respondent's acts and conduct constitute violations of Tennessee Code annotated 62-13-403-1, which states that a licensee who provides real estate services in a real estate transaction shall owe all parties to such transaction the following duties, except as provided by Section 62-13-405, in addition to other duties specifically set forth in this chapter or the rules of the Commission. Diligently exercise reasonable skill and care in providing services to all parties to the transaction. And with respect to this conclusion of law, I would ask that we make reference to findings of fact 13, 14, 19 through 22, and 25 through 32.
You've heard the motion by Commissioner McMillan. Do I hear a second?
Second.
Second by Commissioner Norland. Any discussion on this motion? Hearing, yes, Commissioner DeShara.
Question, is that TCA 62-13-403 or 405, Austin? In the findings of facts, it says 403.
403.
Thank you.
That's 403. Any other?
I'm sorry, on that same point, did you say 403-1 or 2?
1.
So does it, in here it says 2?
That's a misprint,
Okay.
unless this book is wrong. Is this book right? I'm just going by what it says in here.
I brought mine, I'll just double check.
Okay.
Let the record show that in the proposed findings of fact and conclusions of law that has been presented us by the state, it shows on the last page that shows it as number 2 under Tennessee Code annotated 62-13-403, but it should be 1. That's a typo, and Commissioner McMillan's rightly states that it is number 1, and you've heard the motion. Any other comments or discussion on Commissioner McMillan's motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
I'd like to ask the court another question. Since that particular code section is referred to in the complaint, can that then serve as the basis for a finding of violation of 62-13-312B-14, which says violating any provision of this chapter? But 312 Section 312B says, 312B14 talks about what the commission can punish licensees for, and 14 says violating any other provision of this chapter. And since we found a violation of Section 4031, will that justify us and then going in under 312B14 and saying that there was a violation of 312B14?
I think because that's talking about the penalty, and it says to take appropriate disciplinary action such as revocation, suspension, civil penalty under Tennessee Code Annotated Title 62, Chapter 13. I think you're talking now about the penalty phase. Is that correct?
Right. Well, if we wanted to penalize the licensee for the violation of Section 4031 that we just found, do we need to then also find a violation of 312B14, which ties it into the penalty section? Because 403.1 doesn't really provide a penalty. It just says you're not supposed to do it. But then 312B14 says that you can penalize if they, under B it says that you can penalize if they do all this stuff. But then there's a catch-all in 14 that says if they violate another provision. And so do we need to find a violation of 312B14 based on the violation of 403.1 in order to penalize the licensee for the violation of 403.1?
I think that once you get to the penalty phase, you could specify that pursuant to your authority under 6213, 312, B14, that's your imposing whatever penalty you choose to impose.
Okay.
Just make the reference to it.
Yes.
At that time?
Yes.
Okay. Mr. Chairman, I have another conclusion of law.
Commissioner McMullen.
I move that we make the following conclusion of law, that Mrs. Jones' lack of candor on the issue of her escrow accounts leads the commission to find that Mrs. Jones' credibility is at issue. And I would reference finding of fact number 33 for that conclusion of law.
Second.
And that conclusion of law is specifically which?
Regarding the escrow accounts.
The escrow accounts.
6213, 312B,
Well, it's
14.
It's not necessarily that we're penalizing her for her lack of candor, but it's a finding and conclusion that we think she may not be trustworthy, and we are okay to discredit some of her testimony based on her untruthful testimony concerning the escrow accounts.
You've heard this motion by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
That's all I have for conclusion.
Does anybody else have anything to add to the conclusions of law as we make our deliberations?
Mr. Chairman.
Commissioner Grease.
Commissioner McMullen, since I was trying to follow along, but it's hard for me to follow lawyers for any length of time without just kind of fading out.
That's a common...
I understand. So, in our conclusions of law that we've approved that you presented, have we taken into account trust fund deposits? Do we have a conclusion of law that says she didn't handle trust fund deposits correctly?
We have a finding that says that she did not remit monies to the Sniders and Ms. Goodstein that were owed to them.
But as far as the conclusion of law goes, have we got something that, have you spelled out something that speaks to that?
Conclusions of law 28, 29, and 30.
Well,
those are findings of fact, right?
Right. So we referenced 28, 29, and 30 with respect to the failure to remit monies that were owed to the Sniders and Ms. Goodstein. Okay. But I don't think we had an allegation specifically in the complaint that specifically mentioned escrow funds.
Okay, I just want to check about that. And then under 6213-404, in my own mind, she had an agency agreement with the Sniders, but I don't think she ever did with the Goodsteins. Just don't think so. Because you can't have an agency agreement without signature by all parties. But with the Sniders, with respect to the Sniders, under 6213-404, both items 1 and 2, and have you addressed that?
I agree. I think that there was a violation there, but those weren't spelled out in the complaint. And since we can't find a violation of something that wasn't spelled out in the complaint, then I don't think we can get her for that one.
Okay. Thanks.
Any other comments or motions having to deal with the conclusions of law in this matter? If we are finished with our conclusions of law, then we go on to the penalty phase. And at this time, it's up to each of us to decide what kind of penalties should be assessed to Miss Judy Jones. With the testimony that we have heard and the conclusions of law and the findings of facts that we have determined, now we must decide on what would be the appropriate penalty for Ms. Jones in this matter. And the floor is now open for discussion in this area as we conclude our deliberations for this matter.
I don't have a motion, but I would just throw out that under 312B, it says that we can suspend or revoke, and then under Rule 1260-2-.321, we can do a civil penalty of $300 to $1,000 for a violation of Section 50 to $1,000 for a violation of Section 14, and $200 to $1,000 for a violation of Section 20.
So you've got three.
Speak up now.
You've got three sections that you could, so you could, in essence, fine them $1,000 if the commission so choose on each one of those, plus any per diem for when that violation occurred.
And related costs.
Pardon?
And related costs.
Yes. I don't mind sticking up to my views.
Speak up.
I think that this commission is charged to protect the public. And the only way you're going to protect the public is take this lady out of business. She tell you that she's got 2 accounts with $25,000 and 2 accounts, and before it's over with, she's got 3 other accounts with over $250,000. What bothers me is what's going to happen to those accounts once she finds whatever this commission decides to do.
Yeah, and those clients.
I don't know whether we have, Your Honor, I would refer to you this is whether you can protect that or put a hold on that escrow money until you determine whose it is and then that it properly be dispersed. I just got a feeling that it's going to disappear. If you got a lady that will manipulate and move from one account, escrow account to another, you've got a problem. And when you've got somebody that decides that they're going to hold and not disperse, whether it be to the people that do it or whether you're interpleaded, it's a complete, to me, violation of everything you can do. This lady has taken it up on herself that she sits us here and tells us that the lawyers, the judges of Superior County are all in cahoots together and nobody gets a fair shake. But especially if you're dealing with her. Thanks to her. you know, everything's wrong, you don't, she wasn't concerned enough to turn a claim into her own E&O carrier when she thought there was a lawsuit coming. I just don't, and with all that saying, I move for revocation, plus a maximum penalty. Mr. Chairman, that is my motion.
And I'll second that motion. That does include all court costs assessed to her.
Court cost $3,000, and if anybody wants to add the per diem per day, I'm open for that for a friendly amendment. But revocation,
Restate your motion after the comments from Commissioner DeShara.
my motion is, number one, that we revocate her license. Number two, there is 3 different penalties that we can charge, a maximum of $1,000. Plus you have the right to add a per diem to that. Now, my motion is for the $3,000 and the revocation, but I am open to a friendly amendment if you want to put some per diem to that.
And you said this, and the court costs,
All expenses.
all the costs associated with this hearing.
Yes.
I seconded that.
You've heard the motion. That Commissioner Alexander makes a motion that we revocate her license, that we fine her $3,000, and assess her all the costs of this formal hearing.
Yes.
And seconded by Commissioner DeShara. Now, any discussion?
Yes. Your Honor, I'm still waiting for guidance from you about whether we can, whether this commission has the authority to freeze those escrow accounts.
Unfortunately, an administrative body only has the authority that is provided to it by statute, and there is no authority to enjoin in an administrative proceeding.
There's nowhere in our, where we can do it. Mr. Note McMullen, I'm looking for you down there.
She
Since I didn't hear what I wanted
the
to hear.
maximum of whatever can be done to her to be done.
We're discussing now, and the council has said that we don't have anywhere in our statute the authority to add that to our deliberations. But she has about 100 houses that she's managing. What she has done and the way she has behaved gives this industry a bad name. But I'm going to throw the question out as we discuss revocation, whether or not a suspension of a year or so, and I mean, I don't know if it's in our statute that we can require education, but I mean, if we revoke her license, then what's going to happen as she winds down all these 100 or so properties that's under management with her company, where she's the principal broker? I don't know the answer to that.
Well, there's a few things. She could go out and hire another broker.
Yeah.
I mean,
I would not allow potential for her doing more harm to hold us hostage to metering out the punishment that we feel appropriate in this issue. I know that there is that possibility, but the question is whether or not she would do more harm if we allowed her to stay in the business. And I agree with Commissioner Alexander. Based on testimony and prior knowledge, I would say that this is not a person we want to leave in the industry with the responsibility of handling other people's money.
I think that escrow account will disappear before it's over with. It'll be in a different account.
Here, if I may make a suggestion, I mean, and preceded by a question, would you consider the revocation of her license to be permanent permanent or temporary? I mean, if it were temporary, you could impose conditions upon reinstatement of her
Mr.
license
Chairman.
at some point in the future.
Commissioner Collins.
I was kind of thinking along the lines with you of maybe suspending them for 2 years, provided she retake all her broker exam, because she thoroughly does not understand the broker law, and keep her without a broker's license for at least 2 years, and penalize
Go ahead. I've got a question for Ms. Maxwell here in a minute.
and throw out the penalty, but don't even let her test until she paid back dispersed all her escrow that we didn't question today.
Ms. Maxwell?
For question.
Yes. If you wish to request additional information, you will have to, by majority vote, suspend deliberations.
That's not necessary, though. My question was, and I'll leave it.
Speak for the record, Commissioner Alexander.
When Mr. Collins refers to her education, I was simply going to ask Ms. Maxwell to tell the commission the amount of education if she has that in front of her. But now, we've got to open back up to this lady.
Yeah.
Right.
Well, she already testified
She
about
testified to that.
Yeah, she testified about her
She is at
education.
CCIM, and then she's got on her website her other education. And she on her website, she says she the most highly educated person to deal with in Sevier County, or something to that point.
Which, what her testimony was, isn't much competition.
Yeah.
I would like to call on Commissioner Grease to have the floor.
Just a clarification of your motion there, Mr. Alexander. Revocation effective when?
Well, she's got to sign, if I'm not right, sign a consent order to that. Is that, well, it's a minute today. Is that possible, or whenever?
That's the way the order goes to her.
You got to have the order. The order's got to go down, huh? Isn't that right, John?
I'm sorry?
The revocation takes effect when?
Well, it would be at the point that the order was entered, subject to an appeal and a request for a stay.
But my motion would be, what my intention, my motion is sooner the better. As soon as ever all appropriate legal action is taken. And my motion for further clarification is for permanent revocation.
Commissioner Northern.
We're dealing with an individual who doesn't recognize judgments handled down by a civil court. I doubt seriously she's going to take us seriously. I think we should be concerned about protecting the public through whatever means we have as a resource. And where we can't individually mandate removal of any accounts that she might have to prevent further fiduciary loss, we can make certain that we publish it through whatever means we have at our disposal, and that it be made known through the resources available in her area, so that those owners who are privy to that information can take whatever appropriate actions they feel necessary.
See, if the Sniders knew about these other accounts, they'd already filed a lien against those escrow accounts. You're talking about somebody that's street smart, as I call it.
Well, this is public record, so maybe the Sniders will get this information.
I mean, I'm going to rely heavily on somebody who is a property manager, handles, been in it for, I don't know how many years you've been in it, Commissioner Northern, but you know this industry so well, and you have seen what this individual has done. And I'm going to rely upon your knowledge and your opinion as I make my vote, and I think you've made yourself clear.
It's not just what she has done, but it's the attitude displayed with regards to the requirements of following the laws and following the rules of this industry. If I were basing it solely on what she had done, I might consider suspension. But based on the attitude displayed here, I can't in all consciousness say that I want to see this lady in this industry.
Well,
Mr. Chairman?
One thing.
Yes, Commissioner.
Go ahead, Mr. Charlie.
Yeah.
One thing that we need to remember, too, is she has had 7 complaints filed against her personally. I mean, I don't know how many this commission has heard in the past, but clearly she has got a history of disobeying. And she certainly has blatant disregard for this commission, because she sure didn't even want to hear what we had to say.
Mr. Chairman?
Yes.
Call the previous question.
You've heard the motion. I'll repeat the motion. Revocation, $3,000 fine, and the cost of this deliberation, all the court costs associated with this formal hearing today and all this deliberation be assessed also to Ms. Jones. Question has been called. All in favor say aye.
Aye.
No? Let the record show that the vote was unanimous. Judge, this concludes our deliberation.
We still have our policy statement.
Yes, I'm sorry, we have a policy statement.
Policy statement.
Commissioner Alexander summed it up when he started.
Yeah, that's what I was going to say. I guess I would move that we adopt the following policy statement, and feel free to jump on board here if you think I missed something. But we have decided to revoke this licensee's license based on the evidence that we heard and our duty to protect the interest of the public. Based on our findings, we do not believe that allowing this licensee to continue to act in this industry would be consistent with safeguarding the interest of the public based on her actions that have been proven here in our testimony as we've heard it and the exhibits that we've seen.
You'd like to put that in form of a motion as a policy statement in this matter? You've heard Commissioner McMullen's motion read into the record. Do I hear a second?
Second.
Any discussion? And I would like to ask counsel, ask Judge Summers, if this you think is appropriate for a policy statement.
It is a good policy statement.
You've heard the answer from Judge Summers. Any discussion? Hearing none. All in favor say aye. Aye. Opposed, no. Motion carries. Now we're finished. Do you have anything further, Judge Summers?
I just wish the record to reflect that the deliberations were done in the absence of the respondent who was otherwise present for the hearing, and I have nothing further.
Does State's Counsel have anything further to add? We've kept you a little longer. Those of you who are in attendance, we kept you a little longer. I made the decision about 4:15 that we were close enough to the end and I wanted you to see the conclusion of what was done today. This is some of the things that your commission does. And in the morning for about 3 hours, you'll see other things that the commission does. But at this time, you go back there and sign out, and we'll see you in the morning at 9 o'clock. Meeting is recessed until the morning at 9 o'clock.